Today at 2 o'clock.
Pardon, my lord. Item number 64. Today list, my lord. In this case, my lord, your lordship, last occasion, my lord, directed me to obtain the 202 CRPC statement, my lord, in a complaint case, my lord. Some time required, my lord, 2 weeks time. 64 to 2 weeks times. 64.
Item number 1 of today's list, my lord.
1.
Yes, my lord. Due to
64.
unavailability of learned senior counsel, Mr. Sandeep Mohanty, I Supreme Court
Yes.
because of that lining matter.
This is item 1, huh?
Yes, my lord.
Ravi Narayan number.
Yes, my lord.
Who is this Ravi Narayan number?
My lord, he was an ex-IAS officer.
Not the former minister.
No.
It's otherwise related.
No.
I was just wondering the name. Okay.
My lord, we may be pardoned, my lord.
We'll see April first week, Jesse. Okay.
Your Lordship, item 1.
We may pardon, my lord. We may be pardoned, my lord. My lord, CRLMC 738 of 2024. My lord, it is a compromise matter and both the parties have come today. Unfortunately, my lord, the matter could not be listed.
You were telling 2 o'clock.
2.
If they are there,
They are highly obliged, my lord. Highly obliged.
yes, Mr. Ponda, you were
My lord.
telling.
That item 26. 26, probably your lordship will not hear it.
I was just wondering, I'm not able to recall.
A TRP was filed by your lordship just before elevation.
Okay. Then I'll release it to be listed before some other page. Right. Thank you very much.
I came to know about it in the evening. When
I
the
had no
client
idea.
told me.
The order was also
Yes.
about to
So
sign and it-
Therefore, I called.
Thank you very much. Thank you very much.
My lord, item number 38 permitted to
Withdraw.
My Lord, item number 39. Earlier from Mr. S.K. Patnaik. The case matter is adjourned to one next
It
week.
is
Item 39.
it is a fresh matter or no?
Fresh matter, my lord.
Fresh matter?
Very much. Today, in today's supplemental,
Yes.
item 39.
Yes.
Pardon to make a mention.
Adjourned. Next week, my lord.
Not in the list, press admission only.
Take please.
I may pardon, my lord. My lord, in this case, other two co-accused person, your lordship granted bail. Pageant petition similar situated. Can, my lord.
Okay. Item 1 is adjourned. Next, bail matters. Starts from.
Yes, pardon to mention, mentioning out of list for fresh admission, my lord, CRLMC 742 of 2024. My lord, no cognizable offense is there against the petitioner. NBW is issued.
NBW.
NBW.
Give it this.
Okay.
Anybody is there in VP? No. Okay. Item 30. Shall I start adjourning the matter? Because see, indication is there, bail matter. It's not since last 2 weeks. This is happening.
In spite of that, they are not.
Send the message that today I will be liberal. From tomorrow onwards, I'll adjourn it to May.
Fine.
If they don't want bail, then what to do?
Fine.
We'll see. Today, let us be liberal. Yes.
21.
On behalf of Mr. Jena, may I please your lordship?
Yes.
My lord, alleged offence is under section 20B to C of NDPS Act, my lord. The alleged contravened article was seized, that is 74 kg, my lord. But at the time of my lord,
Charge sheet is filed.
charge sheet filed, my lord. Trial is to be yet to be commenced.
You are in custody
Since my lord 5/2/2023,
5/2/2023, about a year.
more than 1 year, my lord.
1 year.
My lord, you have not received the.
My lord,
Yeah, my lord.
my lord, in the page 9, the lower court has already observed that.
But what is your role? What is the
My lord, the petitioner is the driver of the auto.
from
The
where,
co- my lord,
where the contravention?
my lord.
Get purpose for red-handed, my lord. While driving.
My lord, in the
1 year. CD is there?
CD not there from that.
Call the CD next week.
my
Without CD,
my
not.
lord.
Final pair also not there.
Final
All the
pair,
CD will give.
it is observed in the yes.
Let us-
My lord, my lord.
Let CD come.
My lord, my lord. Obliged, my lord. Next week, my lord.
32.
32 paper pass over short pass over mano. Problem.
May I please illustrate? Hello, offense under section 20B 2C of NDPS Act. Petition is in custody 25/11/2023. Prisoner more.
Yes.
Custody is in 25/11/2023.
What is recovered?
Controversy, my lord. One council filed a case and another council are prisoner petition there. Who will argue, my lord?
My name is my in my favor.
But you sort it out, who will appear?
Once, my lord, the prisoner petition come here, my lord. That's why allow the prisoner petition. My friend will argue another case.
No, both are both.
cases.
Both cases in my favor. In my favor.
Send the prisoner petition.
That mine kindly have a glance page number flag A.
But you sort it out, who will appear?
This is my.
I'm just passing it over. Your brother, you can speak. One of you can argue, no problem. What is the contraband seized?
30 kg, my lord.
30.
30 kg.
So I'll grant the bail, but you decide.
Prisoner petition in my favor, my lord. Flag A. Also,
And record the appearance of both of them.
yes, Lord.
Both of them. And
Yes, Lord. One more thing, my lord.
The outsider what?
No, in Manos, local person, my lord. In Manos,
One case, my lord.
one artisan is there.
One case pending against
My lord, in this case, he was released on bail.
1 minute. Let us see. There are two matters there.
Yes, Lord.
One is that is
DLFL 202.
Manas legal.
Manos in
Acha,
And that was already bail out.
in BLFL number
in
4.
Manas, 1 minute.
Sorry,
Two,
sir.
two laws doesn't mean that they simultaneously will shout.
No.
Both of you. Give me the Manas.
Yes. This is the Honorable High Court bail order.
Manas legal 202. And people he is also involved in another similar case. Wherein this the coordinate bench of this court, while order dated 24/9/2020 in BAPL number BBL number BLAPL number 4431/2019 has already been granted bail. First or second same court.
Secondary can artisan nahi. DWL.
Okay. Record the name of both of them.
Yes, Lord.
In one matter you write his name, and another matter write his name. Simple. Okay. Give your name in writing, huh?
Pardon, my lord, the previous item.
Pass over. And henceforth, I've decided to adjourn the matter if you don't come in the first one. Because there is a problem in our office, in the sense, if it is not finished before lunch, it's very difficult to, upload the orders. So therefore, you please cooperate. Yes.
34.
May please.
Anyway, he has it come. 32, na?
Yes,
31.
32, my lord.
32.
Here, my lord, 60 bottles of Escop syrups was seized from the petitioner, my lord.
60 bottles.
Yes, my lord.
500 grams.
How many vehicles were there?
3 vehicles, 3 car. First
You-
train, my lord.
you in which car?
I mean, vehicle number, my lord. OD02 1162 Hyundai car, my lord.
3 first accused in such case, delegation from second case. There were 3 cars apprehended. From where? From all the 3 cars. What is the total recovery?
My lord, mine 60.
60 kilo ganja was recovered. In so far as the vehicle in which was driven by the present petitioner, being vehicle number
OD02
OD02
66
66
1162
1162 is concerned. 20 kilo of
22 kg 900 gram.
2 kilo 900 kg of contraband ganja was seized. Vehicle.
My concern may record it, not allowed, but since joint seizure, my lord. One seizure.
Mr. Raghuda submits that since the seizure is joint seizure and 66 kg 500 grams
More than
seized, which is beyond the commercial quantity. Therefore, the petitioner is not able to use bail. However, taking into consideration that from the conscious position of the petitioner, only 22 kilo 900 C is granted. 35. Yes. 36.
Yeah, please, Your Lordship.
Yes.
This is, Lordship, though initially offense was under section 363, later on 360, 366 and 376 2N and 6 was added to the admitted fact is that both the petitioner and that victim girl is in law. She has admitted in her.
Show me 164 you have.
That is, it is already in the improved order also. It has been reflected in
Where is
the
164?
164 is not with me, but it is reflected in the order. So you all may kindly see, turn to page number 88, Annex 1.
My lord, 64 is available, my lord.
It is, she has been admitted that she was in love with then she got pregnant and the child is also delivered in the meantime.
Meantime.
They are married.
They married in temple. They
No, my
stayed together for more than
There
8
is
months.
no information, my lord, of the present status of the victim, my lord. In between that victim has been blessed a boy child, my lord.
That is
This is the problem.
last date of hearing also, that therefore the notice was issued to the now they have taken, the parents have taken the girl. But it has been, but the petition is in custody since my lord 4th of November 2023. In the meantime, charge sheet has already been filed. Custody introduction is not
The
necessary.
last direction was to for the state to take instruction whether the victim or her son are staying with the parents. Or, and what is well-being.
That instruction, my lord, has not come, my lord.
May I
That is
please,
that,
my lord, appearing from the informant side.
yes.
My lord, the informant and the victim is very much present here.
They are staying together.
Into them and suddenly assaulted son by her son by means of lathi.
But my lord,
Petitioner aged about
CD is not
19
available, my lord, by the order of our learned court below, my lord, that injured sustained grievous on the
Call for CD.
forehead, my lord.
Call for CD. Okay. CD.
Yes.
There
Next
is
to
that. Let us see.
Yes.
Call for CD.
petitioner. Yes. Next to my.
We'll give it a do.
Oh, yes.
38.
Withdraw.
No, withdraw.
Withdraw. 39. Arjun.
Adjourn.
Somebody is asking for Arjun. 40.
My lord.
Yes.
I can't pass over.
Pass over.
Mala, I am for information.
Pass over.
41. May I please?
Yes.
Charge sheeted under section 376(1), 498(4) of the POCSO Act. Your Lordship, kindly have a glance to the statement of the victim under
You are
160
custody
since 12/12/2023.
Huh?
12/12/2020, December 12, 2023. Your Lordship, kindly see there are two parts. On one part, the victim has stated that there is a love relationship and the present person has sexually assaulted her. That is 2021. In 2023, they got married, lived in the house of the petitioner for about 8 months. Subsequently, there is a torture for demand of dowry. Accordingly, due to torture, she left the house. That is the second part. But Lordship, kindly see the 164 statement certified copy.
My lord, here is what problem, my lord. Earlier, this petitioner has granted the bail with the conditions. But this petitioner did not comply the order of this honorable court. ଏଥିରେ 31 ରେ ତାଙ୍କୁ କହିଥିଲା ପଇସା ଇଏ
तो 11/12 लॉग है कि
ଏଇଟା ଟିକେ ଭୋକ୍ତା ଟିକେ ଦେଖିଦେବେ ତ। ରାଜକୁମାର ବେନିଆ ରାଜକୁମାର ବେନିଆ 30/1/2024। हाँ no yes my lord, I'm sorry, my lord, the Instruction victim is willing to join the company of the petitioner, my lord. Sorry, my lord.
No, this is something else you are.
Yes, my
You
lord.
are referring to some other matter, it seems.
Other bill.
This is, I'll tell you, this is Rajkumar Venia. If you see the last order says, Mr. D.R. Bhuktal and counsel for the petitioner submits that the perusal of the FIR would reveal that the petitioner and the victim were married to each other, and thereafter it has been alleged that she was tortured and thrown out of the house by the petitioner and family member. And he submits that the incident was the result of a small misunderstanding, and the petitioner wants to take back the victim to his house as he is his wife. Please the matter on 15/2/2024 to enable Mr. Mishra obtain instruction if the victim is willing to join the company of the petitioner. Have you sought the instruction whether the victim is willing to join the petitioner?
164 is there, my lord.
No, last order you have to comply. Last order up to the coordinate bench is that you are supposed to seek instructions. I'm just passing it over.
No, my lord. No, my lord.
I'm just passing it over. Check it up
Yes, my lord.
and tell me.
Yes, my lord.
I'm just passing. 42. See the last order and
Yes,
tell
my
me.
No, my lord, but till right now, my lord, that instruction has not come. My lord.
Ask.
I am taking instruction.
Somebody's liberty is there. You telephone and call.
I am taking.
Otherwise, we'll grant bail. If that is the case.
My lord.
42, your lordship, may kindly pass over item 42.
40?
42 kindly pass over, your lordship.
Yes. 43? Yes. 43? 44?
Pass over, lordship.
Yes. 45?
45 will kindly take to 1 week after, my lord. On behalf of SK Biswal.
46?
May I please, your lordship? 307 along with other offences, my lord, so far as the petitioner are concerned, so far Ajay Das, Vibhu Das, Ashok Das and Anil Das.
How many of you are there?
Four accused person.
Okay.
Allegation against Ajay is concerned, he has given a slap to the asked about her niece, thereafter he slapped him. And allegation against 2 persons, my lord, they were not the petitioner. That is Ranjan Das and Niro Das. They are throwing bomb. That is the allegation as per FIR, my lord. They are not.
Accompanying them.
Beg pardon?
You are accompanying them.
First.
You are the bomb squad.
No, it's not squad. There is a dispute, my lord. I am read out the FIR.
Hey, what are the allegations against Ajay Das, Vibhu Das?
So far as the Ajay Das is concerned, asked about her niece, my lord. Thereafter, he has give 2 slaps. That is the allegation. So far as the Vibhu Das is concerned, my lord, other 2 are concerned, Ashok Das and Anil Das. They are not named in the FIR. Subsequently, they have been added. And
why have you jointly filed this thing?
In lower court, they have filed, my lord. They are sending. That's
Jointly
why.
filing is dangerous.
No. So far as the throwing bomb is concerned, my lord, that was against one.
Let us see what is the allegation. Charge sheet has already been filed.
Charge sheet not yet filed, my lord. Custody, my lord, since more than 3 months, my lord.
That's right. What are the injuries?
Injury is concerned, the petitioner are not the assailant, my lord.
Maybe you are the gang member.
Accepting Ajay Kumar, my lord, first petitioner, number 1. All other, petition number 2, 3, 4, cogently assaulted the injured person. There are 3 injured persons.
Grievous injuries.
Grievous injuries.
Call CD.
No.
We'll see.
No, CD
is available, but charge sheet has not been filed. Investigation is on.
Charge sheet कितने file करें?
It will take some time, Lord.
Ajay has no problem. Eh?
No problem.
Ajay, all up. Your lordship kindly consider That
Say-
petition number 3 and 4, my lord, they were not named in the affair.
Injury by
Subsequently-
the injury sustained by means of bomb. Your lordship knows. So let them to approach after filing of charge sheet, and this so far Ajay is concerned, your lordship may grant bail.
No, so far as the bomb is concerned, my lord, that was allegation against one ঠেলি দেবার শূন্যবাস দাস তଳେ পড়িগলা রঞ্জন দাস পিতা ভরত দাস নীর দাস আলিয়াস নিরঞ্জন দাস পিতা বাଉଁଶୀ ଦାସ ଉଭୟ 2 ଗୋଟି ବମ୍ ଶୂନ୍ୟ ଦାସର ଦୁଇ ପାର୍ଶ୍ୱରେ ପକାଇ ଦେଲେ। 2ଟି ବମ୍ ପଡି ଶୂନ୍ୟ ଦାସର ବାମ ଗୋଡ ଓ ବାମ ଗୋଡ ଶରୀରର କିଛି ଅଂଶରେ କ୍ଷତାକ୍ତ ହୋଇଛି। That
ସମ୍ପୂର୍ଣ୍ଣ
is
ନଷ୍ଟ ହେଇଯାଇଛି।
allegation against
সম্পূর্ণ নষ্ট।
they are not here the petitioner, my lord.
Bibu Das is the assailant. Then
Thereafter, my lord,
Ashok Das
রঞ্জন
and
দাস
Ajay Das.
নীরজ দাস উভয় 2 গোটি বম ফুটাইলে ডান গোটি সম্পূর্ণ নষ্ট হয়েছে। That is the injury report, your lordship kindly peruse. That is allegation against Niro Das and
But the injured statement is very important, my lord.
Ajay Das না নাই।
Ajay Das
Na.
নাই। Ajay Das
Other
was
Das,
there with
Bibu
them.
Das,
But-
yeah भी ना नहीं
I
again.
will give bail to Ajay Das and
Yes.
wait till the charge sheet.
Yes.
Right now,
Yes.
the present petition is filed
Injured
by 4 accused persons for
কেবল
grant
অজয়
of
কথা
bail.
বলবি।
Grant of bail
এটা তো injured case টা
in the case in case number shown so ठीक है ठीक है the allegation in the FIR is ये इधर investigation था तुम्हें 8 case 10th में 10th so far as the applicant number 1 Ajay Das is concerned, there is no specific overtake imputed to but the other accused are the overtake attributed to other accused are under investigation. That has not yet been filed. Not yet been filed. Mr. Maharaja appeared for the same subject that the investigation is still on. The complexity of the accused are yet to be ascertained from the taking into consideration the overtake attributed to the accused number applicant number 1 Ajay Das. I am inclined to grant admit him to bail with the condition that he shall cooperate with the investigation and your conversation. And so far as the other 3 accused persons are concerned, they may renew their bail plea after the charge sheet is filed. Yes.
Obligation.
47.
37 my lordship. Petitioner custody since 12th December 2023 lordship.
Yes.
Initially FIR has been lost unknown persons 379 and IPC, subsequently turned to 379, 413 and 30 for IPC lordship.
379.
Yes lordship.
Yes. What have you stolen?
The motorcycle lordship. And here in this case the petitioner is the motorcycle choro having the receiver of the many criminal
How
antecedents.
many?
No, this petitioner is concerned 6 antecedents.
Only.
After they are that case arrested, they are the remanded.
Then 3 months. 3 months every
yes.
week. 3 months every day.
चोरों गुड़ा तो
Then 3 months every week.
yes sir.
Go and report.
Obliged sir.
48.
Your lordship, the allegation under section 307 of 506.
That case investigation is still on. Or charge sheet
I'm
filed?
sorry.
Just check it up.
No, charge sheet filed on 2/2/2024.
Charge sheet filed. Charge sheet.
And he should report the PS
Report period
for a period of
3 months.
Yes.
3 months.
May I please your lordship, allegation under section 307.
49, huh? 48.
My lord, 48.
I did 40.
Allegation is that on alleged date 26/12/2023, all the petitioner and other 2 persons, they enter the house of the informant and abused her in a filthy language and assaulted by the body, a wooden stick. So that he sustained injury and thereafter when her husband came, they also assaulted.
They also
What-
accepted.
what-
And here, when his son come, they assaulted with a beer bottle, broken beer bottle.
Let
Okay.
us see what are the injuries.
A injured Soumya Das, Somanath Das. He has sustained grievous injuries sustained by assault of a beer bottle.
Mine.
And the another injury is injured Indumati. He has sustained 2 laceration injuries.
Who has given that beer?
This
beer
petitioner,
bottle,
this petitioner.
No,
this
there are
petition.
two petitions. Hon'Ble Behera.
Hon'Ble and
Buttu Behera.
yes.
Who has given that law?
Kitchen hai.
Huh?
Omnibus allegation.
Hon'Ble Behera, Bullu Behera, ନୟାଗଡ଼ ସମସ୍ତେ ମିଳିତ ହୋଇ ଆସି ହଠାତ୍ ଆମ ଘର ଭିତରୁ ପଶି ଏବଂ ମୋର ମା ଇନ୍ଦୁ ଦାସକୁ ସ୍ଲାଙ୍ଗ ଲାଙ୍ଗୁଏଜ ଠେଲାପେଲା କରି ତା ଲୁଗାପଟା ଟଣା ଉଟରା କଲେ ଓ କାଟ
Item 4. Item 5.
May please, your lordship. Five petitions were filed before the London trial. One petition was allowed. That relates to examination of defense witness. And other 4 petitions were rejected. I am not raising 2 petitions relating to.
Now you have filed 5 petitions?
No, 4. 4. Out of 5, 1 was allowed. I have challenged 4 petitions. Out of 4, my lord, I am not raising 2 petitions.
Four means 5, 6, 7. No. What is that?
One is to call for the general diary from the Abhay Chandpur case, and another is for the call for the general diary from the case. I am raising 2 petitions.
Okay, what you are intending to tell is,
Yes.
under Annexure 1, there are 4 applications you move. Isn't it? Out of the 4 applications, 1 is allowed. The other 3 are rejected.
Of the 4, that is wrongly mentioned. Of the 4 were rejected.
Okay, 4 applications are rejected.
Rejected. Out of 4, my lord, I have challenged the 4.
5 applications you move.
5.
Okay.
Out of 4, my lord, I am not raising 2. That may not be very important, my lord. And
1 is allowed. 1 is allowed. There is no problem. 1 is allowed. Which are the 2 applications?
2 applications
Come to Annexure 2.
Yes.
Come to Annexure 2.
Yes.
Which are the 2 applications you want to press now? If you come to Annexure 2,
regarding
it is
page 9, your lordship again.
file 5 separate petitions.
Yes.
Which one?
Your lordship can see page 8.
Now you come to 12. 12. 12. 1, 2. Page 12.
Yes.
Come to page 12.
Page 12. Yes, madam.
Page 12. Have you got it?
And now I am
all the
pressing
applications are mentioned here.
mentioned.
Which application you want?
2 and 3. Clause 2 and 3.
2 and 3.
Miller.
But let us see what is 2. The second petition has been filed with a prayer to summon and because production of the general diary
General diary.
of registrar of so consisting of so and also summon the diary of charge officer and charge so. And third application in prayer to summon and cause production of the general diary. So same.
But different date. Different date.
13/1/2022.
15/1/2022. Another is 5/12/21. 3/12/21 to 5/12/21.
Okay.
Why it is necessary, my lord?
Defense evidence. You want to lead defense evidence.
Yes.
On your
defense evidence was allowed. But
you want to summon this.
Call for the general diary. Because my
What
lord,
is the offense?
offense is 353 and 395. The case.
What do you want to get out of it?
Yes, my lord, that I am telling you. Your lordship, well, I want to disprove that the general diary entry was not made. If then general diary entry is not made, my lord, he was not on the informant, the police officer, the IO was not on duty at that time. I want to.
Have you posed this question to the IO?
Yes, my lord. Your lordship may kindly see paragraph 27 of the cross examination.
Which page?
Page 15. Internal page 15. I have supplied.
1 5.
May I read the relevant portion, my lord?
Yes.
I have made general diary entry while leaving the PS, along with the accused Devendra Sain for recovery of the concealed service pistol in pursuant to Exhibit 1. And I cannot say the general diary entry number in this regard. The general diary entry discloses at what time he left the PS. It discloses. That is necessary.
But not separate the copy manner of the.
So, what will pass it? Sabuda deli.
Copy down देना है.
अभी
पूरा कॉपी दियो तो चेक करिए पासवर्ड कौन सा just examine whether we can summon this because
That is no relevance, my lord, at all.
that is what you have to check whether relevance because he has posed this question to the
Madam, he may lead this document to the defense, my lord.
नहीं सेटा असला नहीं.
Defense allowed he actually
say
himself.
he wants to lead in defense only.
Madam, defense would he can cite defense and obtain the same.
Defense will
That is a public document, madam. He can obtain the and affect it.
public sir ଆସିବ କେମିତି ସେଇଟା ତ କହୁଛି.
Okay, but RTI magi kariyo.
RTI मागिरे out दिमाग लागियो
This case, that is no.
My lord, sorry to say in Odisha it is taking 3 years. They are not solving.
so RTI यदि relevance ଅଛି
Relevance.
ले लाओ after all his defense relevance नहीं गले देखी दियो तो
ये 40
it will be passed over or you need it
out of date लो
adjourn करो
सेटे
थोड़ी दे दे मैं verify कर दे
ये वेरीफाई कर दिया
verify करे
They short date.
short date ही
आइटम 42 टा लॉट्स में आइटम 42 टा
42
यस सीनियर अटॉर्नी
42 अच्छा 42
Yes.
42
yes 42 yes
Wait, please, your lordship. The petitioner before my lord is has been charged sheeted for the offences under section 506, 76 to N by 294 of the Indian Penal Code, my lord.
yes
The victim here is a widow of 37 years and petitioner before my lord is a practicing lawyer of Bhadrak. She was conducting her case, my lord, and she has also stated so in her 164 statement. ମୋ ଓକିଲ ଥିଲେ ସେ ମୋ କେସ୍ କରୁଥିଲେ ମୁଁ ଫିସ୍ ଦେଇ ପାରିଲିନି.
My lord, if your lordship allow to me, I may be read to the 164 statement of victim, my lord.
Item 6.
But here, Mala, I am challenging the order of cognizance
Yes.
under annexure
yes
6, my lord. Is a case, peculiar case. My lord, this petitioners, my lord. The petition number 4, my lord. He purchased a land from the petition number 2. The allegations made by that one, my lord, Mathura Pradhan, that in the year 97, the petitioner impersonate, he had, my lord, by forgery, showing him to be a scheduled caste person, has purchased the land, has not paid him the consideration money. That is why the case was lost, my lord. And the police, without any inquiry, my lord, gave the charge sheet, and my lord, so also the sub collector, on the basis of the affair, my lord, cancel my all sale deeds without any inquiry, my lord, whether, and incidentally, the name of the father of both the, my lord, persons are same. The sub-register now, my lord, I file an application before the sub-register, you please inquire, because I am a different person and he is a different person. Maybe the father's name are same. Now he, after, my lord, thorough inquiry, has given a report that is, my lord, at page, your lordship may seek, and page 99, annexure 7.
99
My lord.
okay.
That in continuance to this office letter number such and such, I am to inform you that on verification of sale deed number such and such of 2007 and such and such, it is found that the photocopy, signature, age, caste of Dhirendra Kumar Jena, son of Dhirendra Kumar, differs from each other. Both persons are not same, though the name of the father's name of two persons are same, but they are different individuals as per the sale deeds executed before this district sub-register Jharsuguda. And now, here, lordship may see page 101. This is the Dhirendra Kumar Jena who purchased the land from Mane in the year 97. And 102 is my petition number 1. Both are different persons, my lord. Maybe the father's
Devraj Jena and
Dhirendra Kumar Jena, both name are same, and incidentally the father's name also same. But they are two different persons, my lord. And what has happened, my lord, the petitioner number 4 here is the, my lord, local correspondence of Samaj at, my lord, Jharsuguda. The then MLA, he was writing against the then MLA who was, my lord, murdered last year, my lord. And because of that, this false FIR has been lodged. And in the, my lord, in the FIR also he has written that I am, since I am working, the prisoner of 4 is working in Samaj, he is misutilizing his power. This is the case, my lord.
but how does it make difference insofar as cognizance order is concerned?
But I am not the person who was, but the allegation is.
Maybe all these things are your defense.
No. Your lordship may see what is the allegation.
Mistaken identity, whatever you are saying.
Your lordship may
How can you attack the cognizance order
My
on
lord,
the basis of some of your good defenses?
No, but without inquiry, my lord. Well, had there been a police had conducted any inquiry from the church sub-register office that whether to know the identity of those two persons, the police would not have, my lord, submitted charge sheet, my lord. Because without conducting
Wrong, right, whatever. Incomplete investigation, improper investigation, whatever. The charge sheet is filed.
Yes.
And now cognizance is taken.
My lord.
Do I need to go into?
I have not conducted any inquiry. It is the sub-register, my lord, he conducted an inquiry.
This has to be proved. You bring this.
I'll get the certified copy of those documents.
But still, the certified copy of that being cognizance order I can't file. You have to,
I'll cite some
certified copy. You have to place it in the trial court and
that trial, my lord, that your lordship is correct, my lord. I'll face the trial. That is no problem. But here,
you tell me
because of this, my lord,
what are the allegations are there? By accepting that to be true, no case is made out. That's the standard rule.
My lord.
You tell me whether a case is made out or not.
But case
wrong identity, right identity, and all these things.
No, case is on the allegations, my lord, bald allegation, the case is made out. But with the police, it is the duty of the police. But it is the duty of the police to investigate whether this Dhirendra Kumar Jena is the same person who has purchased the land in this.
Paul, I'll give you liberty. You raise all these points.
Well, I'll your lordship may give me some time. I'll cite some judgments that this case can be interfered by your lordship.
Interfere not in cognizance.
Well, I'll cite judgments, my lord. Your lordship will cause the judgment. Cause the cognizance, my lord.
Simply adjourn, my friend may add the complaint as a party as because
Yes.
SCST Act is there, my lord.
Yes, I'll add as a party.
Is there any chance of settlement?
On that basis, my lord.
Now he will settle, my lord. Now he will settle. He knows that his godfather is not there. He will settle, my lord.
So then what is, if there is a chance of settlement, you include the information.
My lord.
I'll simply issue notice. Without saying anything.
Because the SCST Act is there, my lord.
So therefore, Mr. Pal seeks leave of the court to implead the informant in the present case in the opposite party number 2. He may do so during the course of the day and countersigned by issue notice to the opposite party number 2 to explore the possibility of settlement. Right, to explore the possibility of a settlement. Issue notice. Use file process fee, let us see.
Item 7.
Let's pass over. Sorry, pass over is launch for a good idea here.
1 minute, call him. He has some problem after lunch because he has. I'm simply adjourning it.
Yes,
Item 8.
Your lordship is an application under 482. The parties have amicably settled the matter. My lordship.
Parties are there.
They will come on the next date, my lordship.
Call them at 2 o'clock.
My lordship, the opposite party, she's traveling. She will be available. The opposite party, she's traveling. She will be available next week. Next week, any day.
Monday, Tuesday.
Okay.
Tuesday. What is the FIR is 498? Offense. Small offense.
427, 294, 323.
Okay,
Small offense.
28. 20th, huh? You call them so that we can call. Sorry.
But I may pardon, item 7, on vigilance matter, connected matter is of the year 2018. It has preponed.
I am holding the court whole day. It is past over.
My lord has told
Within 2 minutes. I'll just come within 2 minutes. I'll just.
এটা চেক করতে আছে ম্যাডাম পঠে লাগেনি হ্যাঁ ପଣ୍ଡାବୁ ଆପଣ କେତେ ନମ୍ବର ଓହୋ ଆଚ୍ଛା
এইটা 2018টা সেଠିକି ଯିବ ସେଟା ପ୍ରିପନ ହେଇଛି 21 ଦିନ ସେଇ କଥା ଖାଲି କହିଦେବି এইটা এইটা ନୂଆ ମ୍ୟାଟରଟା 2022 ପର୍ଯ୍ୟନ୍ତ ସେଠି 23-24 नहीं नहीं ये जोड़ा से अंकर 23 टा हमर या से वाला ये वाला नहीं नहीं वी थिंक है वुड बी ठीक है
डीलिंग करते
my lord delete so I have
डीलिंग करते
2018 delete.
CRLMs 51 of 2018 be deleted.
Delete kori. Detach. Okay. Next.
Detach.
डीड लिंक कर देबे तो
Item 7 may
कौन
be taken up next week.
अलग है
Item 7 may be taken up next week.
7.
Aye.
That's what I'm saying. Yes. Next. Call freely. Call. 9. Yes.
Oh, please.
May I please your lordship?
Yes.
Now the FIR was registered on section 417, 493, 313, 506.
Okay.
And the cognizance was taken on section 376 2N of the Indian Penal Code. Your lordship, what is it? The informant in this case, your lordship, she has filed an application under section 482, including me as a party. And that case, your lordship, that is CRLMC 1454 of 2023. Informant filed a case that she doesn't want to prosecute further because she got married and having children out of her marriage.
Okay.
So she doesn't. So under these circumstances, I have filed an application before your lordship on section 482 of CRLMC.
Both the court matter can be taken up today.
That I have filed that application, my lord, the other application. Your lordship may call this matter on Monday. Both the matters.
Both the matters call and they settle the dispute. Call the parties also.
I'll call the parties, my lord.
Party so that we can record the statement.
Because my friend's client, you know, she has got married.
Oh, let them come.
No, she has married outside to another person, and she has got 2 children out of that marriage, my lord. Now she is not willing to.
We see, let them appear on.
Well,
Monday, Tuesday. Both the matter, na? Take the other name.
CRLM 1454.
Tell. Then 10. 11.
Item 11, may I please your lordship, I'm seeking 2 weeks time for obligement.
This case, my lord. This I have challenged the order passed by the Lord Judicium Jajpur, my lord, by the annexure 3, order of cognizance, my lord. Here the husband, my lord, has filed a complaint case, my lord, against the wife and her family members, my lord, and the learned magistrate took cognizance. Lordship can the initial statement, what he has stated, my lord, page 18, lordship can. Husband has filed this case, my lord. And then prior to that, my lord, there are no
Against wife.
against wife and her family members, my lord. The father, mother, and sister, my sister-in-law, my lord. The allegation, lordship can see the page 18, my lord. The initial statement, the statement says 200 CRPs, my lord. Lordship can see paragraph 2, my lord.
And my wife called her parents. They came to her house. They also took cold ornament and carried out. Yes.
That, my lord, the magistrate had taken cognizance of 354, 379 and other allegations.
These are the evidence what to do.
My lord, the only prior to that, my lordship can see the there is a police case.
498 case.
498 is the 23,
What is
12
wrong
of the
with
domestic.
cognizance? See, 202, 200.
There is no, lordship can see there is no material analysis to 354, my lord. How the 354 is made out? Lordship can see the 200 CRPs, my lord, page 18. Lordship can see 1 second, lordship go through that. How 354 is made out against the opposite husband, my lord. He has never stated he has the parent father is
Well, they abused me and they assaulted me.
which the how the 354 is made out, my lord.
That charge court will see. Abuse me means what kind of language you used and all. I don't know.
That means the
54 may come.
The
How do I know?
the offender 354 in the
200 statement only.
My
You
lord.
have abused.
The abuse that 294, my lord. 294, my lord.
No, it can lead to 354 also.
If lordship the only to harass the wife, my lord, yes,
That's
yes.
right, but
Yes.
what to do? Is there any chance of settlement? Then I need to simply
Yes, there is a chance of settlement, my lord.
simply issue notice.
Yes.
We should simply notice nothing.
If lordship, unless you stay the proceeding, my lord. There is
This is not a case where I went.
I am proposing one thing, my lordship, subject to lordship acceptance, my lord. I lordship stay the proceeding, lordship direct the issue notice, my lord. Appearance, my lord, lordship direct for a conciliation. Matter can be settled, my lord. The recent marriage, my lord. All the family, they will come to Raul, they come to Jajpur from Raul, my lord, they will appear, the matter will linger, my lord. If lordship, the matter can be settled, my lord. My instruction, the matter can be settled, my lord.
You are the.
I am the wife, my lord. Wife and the.
Are you ready to?
Yes, my lord. My instruction is ready, my lord.
Write down. The petitioner is challenging the cognizance order dated 4/11/2023 passed by SDJM Jajpur in ICC case number 377 of 2023. Petitioner is the wife of
opposite party 2, my lord.
Petitioner number 1 is the wife of opposite party number 2. There are matrimonial dispute pending interstate parties. Let the petitioner submits that as a counterblast to the matrimonial dispute initiated by his clients against the opposite party number 2, the present complaint case has been filed. Since both the cases are arising out of a matrimonial dispute, there is a chance of settlement. There is a chance of settlement. Therefore, he seeks indulgence of this court. Issue notice to the opposite party number 2, written within 2 weeks, and in the meantime, proceeding in the ICC case number 2. So yes.
Okay.
13. May I please?
13. 1-3. Yes.
May I please, your lords? My lord, during pendency of this application, subsequent development has been occurred in the case, and without giving police paper, charge has been framed against the present petitioner, my lord. Hence, I permitted to withdraw with liberty to file appropriate application.
Then constitutional petitioner seeks to withdraw the present petition to evade the remedy under law or to challenge the order of framing of charge.
Yes, Lord.
With such liberty, the petition is disposed of.
Obliged.
My lord, the petitioner challenging the order under Annexure 2, my lord. The petition filed by the accused under Section 239 of CRPC for a discharge of the offence under the ground, my lord. My lord, the petitioner is no way connected to this crime, my lord. My lord, the
This is a
nephew,
cognizance order.
my lord, my lord,
Your prayer is for causing of cognizance.
my lord.
Discharge petition.
239.
239.
239 of CRPC, my lord. My lord, kindly see page Annexure 2, my lord. The order arises of the petition dated at under Section 239 of CRPC filed by the advocate for the accused to discharge him on the ground of false allegation made against him. My lord, the fact of the case, my lord, the petitioner, the complainant's nephew, who is the charge of the cash counter, has with the chatting with the mobile chatting in social media with the one Debasmita Mahanti, my lord. And the allegation is that the present petitioner identified himself as a DCP of the Kotak, has extracted money.
As a close of a relative of
Relative and a DCP of has cheated money from the nephew of the complainant, my lord. My lord,
Rightly to cognizance is taken. What is wrong?
there is no connection with the
Connection or no connection in the trial, it will be decided, not in cognizance stage.
my lord, no evidence that the money has been transferred to the petitioner's account, my lord.
All these things you have to, in the right stage, you have to raise all these points. Charge sheet has been filed.
My lord,
And the evidences are wrong, right evidences are there. Cognizance is taken. And you move an application 239 to
and there is no conversation between the
all these things are the
no
trial
evidence,
stage.
my lord. There is a Debasmita who has been not charge sheeted in the
Can I conduct a mini trial here?
well, the notice may
Why notice unless
No.
the consequent petitioner seeks to withdraw this petition to raise all the points at the appropriate stage in the before the trial court with such liberty the petition is disposed. Yes, next.
well,
15. 15. 15, na?
15.
May I please, Your Lordship?
Yes.
Your Lordship, here the petitioner is seeking a direction for this Hon'Ble Court to quash the entire criminal proceeding on the basis of, my lord, compromise, my lord. Parties
Settle,
are-
my lord. Parties are also present before this honorable court.
Injured Arun Kumar
My lord,
Behera.
Arun Kumar Behera, my lord, he has passed away and by accidental mortgage.
Passed away.
My lord, accidental case, different case. Not in this case. Not in this case, my lord.
Not in this case.
My lord, I have filing the certificate copy. Your lordship may just.
307 is there.
My lord, not in this case, my lord. Subsequently, he has passed away. Your lordship may just have a glance to the.
307. पता चला he died because of.
So far as my
Where
lord.
have you said that he died?
My lord,
My lord,
as for my
Para 4.
Para 4.
Yes.
Page 6, my lord.
Road accident.
0.9, my lord.
Road accident.
Road accident.
Yes,
Road accident.
Yes,
there.
separate.
Just who is Sujata?
Sujata Maharaj.
Mr. Maharaj. Just check it up. And Sibo Charan Das. Ramesh.
Allied offenses and
498, 307, 506, 294, 497, 406,
I have annexed
41,
and my lord,
323, 34 IPC, 4 of 6 of the DPI.
my lord, the
And
matter
he-
Got the husband.
Yes.
my lord, ex-husband, my lord.
Is only prayer to
Divorce has been granted by the
only
government.
prayer to expedite the trial.
Expedited.
When the FIR was lost?
My lord,
2011.
11.
Yes.
My lord, 11, and if I have annexed the entire order sheet, my lord, if my lord comes to
The petitioner in the present petition seeks limited indulgence of this court to limited indulgence of the court for a direction to expedite the trial. In PS case number
85 of 2011.
Sessions trial case number 65 of 2013.
The petitioner is the husband of the informant. Husband of the
Ex-husband, my lord.
Ex-husband.
Was the husband.
Was
the
the
husband of opposite party number 2. Isn't it?
Yes, my lord.
Pavitra Choudhury, opposite
Yes.
party number 2.
And the divorce has
You got divorce on contest.
My lord, it was ex parte in Mata 45 by 2000.
Anyway, on contest, na, you got
Yes, madam.
the petitioner has already the marriage between the petitioner and the opposite party number 2 has already been dissolved.
In MATA 45 by
by the family
2015.
court.
No, my lord, in MATA 45 by 2015.
Matt
By this
Kesson.
all, by this,
Which court?
by this court, my lord.
By this court. In Mata number so by this
45 by 2015,
By-
which is at Annexure 2 series.
However, the criminal prosecution launched against the petitioner by the opposite party number 2 has been prolonging since 2011. 2011. Therefore, he seeks indulgence of this court. Taking into consideration the long pendency of the criminal prosecution against the petitioner and the fact that he has already obtained divorce from the opposite party number 2.
And also complied the order.
That the trial pending against the petitioner is liable to be expedited. Accordingly, it is directed that the which court pending before so court.
Session Judge Ganjam.
Session Judge Ganjam, my lord.
In ST case number
65 of 2013.
To do well to see that the ST case number so and so the trial of execution so it's disposed of actually is possible preferably within 6 months.
My lord, 3 months, my lord.
I don't know how many witnesses.
My lord, I have entered. I have annexed the entire order.
You tell me.
Sakhi, my lord.
How many witnesses are there? I don't know anything.
My lord, they're not appearing. That's the.
Tell me, it should be a practical target.
My lord.
4 ଜଣ ସାକ୍ଷୀ ସରିଲେଣି ତମ ଡକ୍ୟୁମେଣ୍ଟ ତମେ ଫାଇଲ କରି ଜାଣିନ
4 ଜଣ ସାକ୍ଷୀ ସରିଲେଣି
4 ଜଣ
ସରିଲେଣି
4 ଜଣ ସାକ୍ଷୀ ସରିଲାଣି
କେତେ ଜଣ ଅଛନ୍ତି ଟୋଟାଲ
ମୁଁ ଜାଣି ଚାର୍ଜ ସିଟ୍ ରେ କେତେ ସେ ତାଙ୍କେ
Charge sheet annex ହେଇନି.
You want to
whatever document
trial, you don't know anything.
My lord, charge.
Let it be 6 months. You
4
should be
months.
ready with in your finger trip.
My lord, 4 months, my lord.
How many witnesses? Suppose there are 200 witnesses.
No, my lord.
How can I give? I don't know.
ସେଟା ଠିକ କହିଥିଲେ ଭଲ ହେଇଥିଲା ମୁଁ
You
ଯାହା
are asking,
ଦେଖିଛି
these are very minimum.
Pass over, my lord. Pass over.
Do I know password? 6 months. You should face it.
Obliged.
You are asking for expeditious trial and you don't know how many witnesses are there.
If
These
my
are
pass over, my lord,
first
I'll.
preliminary.
ତାଙ୍କ ରେକର୍ଡ ରେ କେବଳ 4 ଜଣ
Charge
ସାକ୍ଷୀ
sheet
ହେଇଯାଇଛନ୍ତି ବୋଲି ଦେଖାଇଛି ମୁଁ ତାକୁ ଦେଖିଛି
It may be one more witness make it.
Okay, but-
I may make it for 15 days.
My lord, my pass over.
What is this? You are a young advocate.
My lord, my pass over.
Pass over. You tell me how many witnesses are there.
With
accordingly I'll pick
yes,
it
my
up.
lord. Yes, my lord.
It should be a practical target, you know.
My lord, my lord.
If there are many witnesses are there, I'll give 2 months. No use.
My lord, my lord.
Again, he will move an application for extension. What is the use of it?
My lord. Obliged, my lord.
17. May I please your lordship? May I please your lordship?
Yes.
The petitioner is widow and scheduled caste tribe, my lord.
Yes.
The petitioner and informant in the relationship between father and the other. That is annexed 1 page 15, my lord.
What do you want?
That is my lord.
And so many facts entangled, so many facts entangled, cross FIR is there, so many things are
ନାଇଁ
there.
ଏଫଆଇଆର ଟା ମୁଁ ନିଜେ ଦେଇଛି ସାର୍ ତାଙ୍କ ଉପରେ
Whatever, sir, you have to know.
My lord,
Please try that.
at least notice may be given, my lord, the informant, at least notice may be given, at least, my lord, ସେ ଆସି କହିବ illiterate person.
କହିଲେ ବି cause କରିପାରିବେ.
Yes, my lord.
ଏଫଆଇଆର ଛଡା ଆଉ କିଛି ଆମ ପାଖରେ ଡକୁମେଣ୍ଟ ନାହିଁ. Whatever document has been annexed, I have seen it. This petitioner and her husband.
We will be wasting our time.
Yes, my lord, at least admit issue notice to the opposite party, my lord.
So you have to satisfy me. Notice is not thing. Satisfy me. I'm not satisfied because see 2 FIR you have filed.
No, my lord.
The facts are
My lord,
entangled.
you may
It's a
kindly
case of
see in second FIR. No, my lord. No, your lordship, to the second FIR, my lord, pardon, your lordship, page number 22, ମୁଁ ପଢୁଛି. 22.
Yes.
My lord, ଦେଖନ୍ତୁ ସେ କଣ କହିଛନ୍ତି ଯେ ତୁ ଫୋନ ନ ଉଠାଇଲେ ତୁମ ଘରକୁ ଯିବିନି, ମୁଁ ଡରି କଥା ହଉଥିଲି, ଯେତେବେଳେ ହସି ଆସୁଥିଲା ମୋର ସ୍ୱାମୀ ଫୋନ କରି ସମସ୍ତ ଆମ ଦୁଇ ଜଣଙ୍କ ବିଷୟରେ କହି ଅଶ୍ୱିନୀ ଘରକୁ ନେବାକୁ କହୁଥିଲା, ଏହା ଜାଣି ମୋର ସ୍ୱାମୀ ରାତିରେ ଆସି ମାରିଦେଲା. ମାନେ that fellow, ମାନେ ଅଶ୍ୱିନୀ ନାଇଁ ମାରା, ମୁଁ ଘରେ ନଥିଲି, ମୁଁ ଘରକୁ ପଳାଇଥିଲି, ମୋର ଶାଶୁ ଘରକୁ ପଳାଇ ଯାଇଥିଲି, ମୋର ପୁଅକୁ ବହୁତ ମାଡ଼ିଛି କହିଲା, ମୁଁ ଘରକୁ ପଳାଇ ଗଲି, ମୁଁ କିଛି ଜାଣିନି, ଅଶ୍ୱିନୀ ରାତିରେ କେତେବେଳେ ଆସିକି ମାରିଦେଲା ମୋର ସ୍ୱାମୀଙ୍କୁ, ମତେ କହିଲା ଯା ଥାନାରେ ମୁଁ ମାରିଛି କହିବୁ, ନହେଲେ ମାରିଦେବି କହିଲା, ମୁଁ ଡରି ଥାନାକୁ ଆସି କହିଲି, ଏହା ବାହା ହେବି କହୁଥିଲା, ବାହା ବି ହେଲାନି.
All these things need to be checked. You
Yes,
have
my
filed the FIR. I don't know, to get out of the
My lord.
charge under 302, you might have done it.
Yes, my lord. I'm admitting your point of view, my lord. And at least, my lord, ମାନେ ତାଙ୍କୁ ମାନେ ସେ ମାନେ ଯୋଉ ଲୋକ ମୋର ନାଁରେ ଦିଅରଟା ଦେଇଛି ସେ ମାନେ ପ୍ରକୃତରେ ମୋ କରିଛି କି ନାହିଁ, my lord, ମାନେ ସେ
Trial ରେ ଜଣା ପଡିବ ନା
ଟ୍ରାଏଲ ରେ
ଇନଭେଷ୍ଟିଗେସନ ଚାଲିଛି.
ତେଣୁକରି at least, my lord, LCR call for my lord.
Why should you waste time of the court like this?
My lord, at least, my lord,
charge sheet file ହେଲାଣି.
ଇନଭେଷ୍ଟିଗେସନ ଗୋଟେ 302 ରେ ଇନଭେଷ୍ଟିଗେସନ ଚାଲିଛି.
my lord, at least
The counsel for the petitioner seeks to withdraw this petition to approach this court at appropriate stage if the cause of action still survives. Investigation ରେ ଆପଣ ଯାହା କହିବାର ଅଛି କୁହନ୍ତୁ.
my lord, at least notice may be given, my lord, at least.
You tell all these things to the police, then yes.
I may be pardoned, my lord. Item number 16, my lord, charge sheeted
Otherwise, I
witnesses.
mean permitted to withdraw, my lord.
I have withdraw with liberty. I have given.
My lord, in that case, my lord, charge sheeted witnesses are 13 and 2 are dead, my lord.
13 to died. 4 examined. 4 examined.
4 ଜଣ examine ହେଇଛନ୍ତି।
4 ଜଣ
ଯାହାର ହେଲେ 7 ଜଣ
7 days 7 ଆଉ 7%
7 ଜଣ ରହିଛନ୍ତି।
7 ଜଣ ରହିଲେ
7 ଜଣ ରହିଛନ୍ତି ହେଲେ 6 months ଠିକ ଅଛି।
ସେ ଠିକ ଅଛି ଆଉ
6 months।
କାରଣ
Let it be 6 months.
ପୁରୁଣା ଲୋକ
It may be over little earlier also.
Earlier also. Decline ବି କିଛି ଜଣ ଅଛନ୍ତି। Decline ବି କରିଛନ୍ତି କିଛି ଜଣ charge sheet ରେ।
ठीक है 6 months is enough. You will also lead your defense.
ସରିଯିବ ଯା
313 is there. So many things.
Obliged, my lord.
May I please? Well, the petition is a complainant matter. Informant, he was facing a cyber crime matter. Even as an Indian soldier, he was transported to Gujarat to Hyderabad. Then his luggage was transported by a company, my lord. Then a phone call was called, and subsequently he was faced a cyber crime, and his amount was after the intimating the cyber police, the amount was held up, and the police has filed a application before the Lord Magistrate to release the whole of money of the complainant in his favor, but the Lord Magistrate has rejected the same. As per the page 21, the
You are
finding.
facing the trial in the cyber crime.
No, madam, I am the complainant.
You are the complainant.
I am the complainant. I am the petitioner of the complainant. My money was held up due to him facing a cyber crime fraud. फोन चला आसला मु इंडियन आर्मी चाकरी करछि मु रुटे जारो आउट ट्रांसफर हेली मो लॉजेस सब ट्रांसपोर्ट रे
केते टका
50,000 ओनली
50,000
पुलिस रेडी टू
एक्चुअली दबा कथा बट नन कोर्ट फिलो एटा दबा कथा किंतु
एक्चुअली
ता मनीटा दबा कथा बट क्वेश्चन इज दैट से खाली डिस्प्यूट कोन करछन 3,000 आउट ऑफ 50,000 has been transferred to other account and the rest 47,000 transferred to other account. So the discrepancy that actually who is the owner or whether that 50,000 transferred to that account, that is a question that has because of which the application is rejected. But when the IO has paid identifying that this amount has been transferred to this account, so this should have been a release in favor of the petitioner.
Where is that order?
Order my lord, page 21 the finding.
Give some surety of well.
ना से 50,000 टंका गोटे सिक्योरिटी देके
दियंतु नहीं जानते।
आज and when record the same shall be produced.
Yes ma'am.
Okay, so today where is that order in
Well, account is mentioned in the order my lord.
Just ये लॉर्ड में kindly see page number किसी की तो page देना
Page 21 the finding of the court below.
Last page before last page my lord.
21.
In the middle portion 1 2 3 4 5 6 7 8 9 10 11 12 13 from 13 it is started. The amount of rupees 50,000 has been debited from his bank account through UPI number so and so and transferred to the account number of a Sayan Kar by the reference number etiki. The IO has got the status report of the UPI number from the SP CIDCB Cuttack. The debited amount has been put on hold by the SP CIDCB Cuttack. Out of the debited amount of rupees 50,000, 3,000 has been transferred to the IDBI account number so and so of a Binayak Trading Co. maintained with Bourbon Road branch, Kolkata, having IFC code number so and so. And the rest amount, that is 47,000, has been transferred to the IndusInd Bank by the account number so and so of Paul and Co. by customer number so and so, IFC number so and so, on 6th floor, cabin number 34A, Narendra Chandra Datta, Sarini, PS Hari Street, near Sagar Estate, Kolkata, West Bengal.
So 50,000 rupees is transferred from his account.
Yes, his account.
And that is disbursed in two way. One is 3,000 to someone and 47 to someone.
Yes,
madam.
Which is has been recovered.
You hold up by the
set of
CIDCB.
CIDCB hold करे.
When I am the intimating the CIDCB.
Hold करती वाले से account to hold करती हो ना.
हाँ से account को hold करती.
से account काट ले तो देव पूछा.
से account न काटे अपन तो सेटा ठीक है.
I will suppose I will pass an order. Where from they'll get 50.
सेटा problem.
ना
तब ये trial रे कौन करा है जी कि after completion of trial the court can reach at a conclusion that who is legally entitled to get the aforesaid amount. That is why
Suppose
this is not. the pro-
tomorrow it is found
Huh.
that Paul and Company, it is a travel agent. It is a world
Not-
famous travel agent.
Normal.
It has transferred to them 47,000.
Yes.
And it is found that no, it was genuinely transferred.
সেটা problem
What will
create.
happen?
No, no, that is not transport company. Transport means another. This is the fraud or mal, the cyber fraud mal.
ନା ନାଇଁ ଆପଣଙ୍କ ଆକାଉଣ୍ଟ
petition.
50,000 ରୁ 3,000 ଟଙ୍କା
From
ଗଲେ
your account 50,000 rupees
Yes, mal.
was
Yes,
taken
yes, mal.
by fraud.
Yes, mal.
Okay, that 50,000 rupees is 3,000 rupees were deposited in X amount, X account, and 47 is deposited in Y account.
The
And
cyber.
now you are asking that, and both the accounts are not freeze.
Yes, mal.
That is freeze. Now you are asking that 50,000 rupees to be given to you. Suppose tomorrow, if that 47,000 or 3,000, wherever it has gone, it is found to be correct transaction.
My responsibility, my lord, cyber crime police, the crime branch said that crime branch has hold of the money. Well,
The 50,000 rupees is lying with crime branch, you show me, so that I can ask for relief. If it is some other account, how can that?
No, that the report is before the police, my lord. They directed to call for the report, my lord, from the
Issue notice.
ଆସ ଗୋଟେ instruction ଦେଖିବ.
instruction is called for then.
If it is lying with them, no problem.
Yes, my
We will
lord.
take it.
The police have said that if an order was come from this court, I am released the amount.
Just issue. I am issuing notice. Let us. Yes, notice. 19.
Yes, my mayor will ask me. Well, in this case, first the complaint was under section 406-34 IPC. And the investigation was completed. The charge sheet was submitted 420 in the name of the Sankar Kumar Mishra. But clearly stated, Lordship will come to page number 27. The investigation officer exercised all the power and evidence that there is no evidence to prove against the present petitioner. Thereafter, final report submitted against the petitioner and final form was submitted in the name of the Sankar Kumar Mishra. Thereafter, my lord, on the 14th, the cognizance was taken and charge also framed. Lordship will come to annexure number 4, page number 29. Well, here one thing is there. In this case, though my lord, present petitioner is a public servant, is assistant professor, the sanction is mandatory 197 service. But that is not bad. Nothing.
What are the allegations?
Allegation
If it
is
coming under the color of duty, then only the.
yes, my lord. Allegation is that the petitioner's husband and the complainant are a business. And both are the medicine representative and they are continuing business as Ranihat. During
Sorry.
medicine, my lord.
Who is petitioner number 1?
Petitioner number no, my lord. Here is the petitioner 1, my lord. The petitioner husband and the informant.
Vijay Lakshmi Das.
If Vijay Lakshmi Das before your lordship, my lord. Vijay Lakshmi Das husband and the informant was correlated continuing a business at Ranihat, my lord. Thereafter, when the loss of the business of the Sankar Kumar Mishra handed over during the loss of the business, he taken 13,000 from the complainant, whom Sankar Kumar Mishra. When he again demand the money, in the meantime, petitioner and her husband purchased a duplex at Bhubaneswar.
What ground you have taken before the court below? Have you stated in your present petition? पहले पहले गोटे कथा बोले कोड इलेक्शन
197 why no 190
सेटा किसी नेक्सस नहीं
नहीं।
there is no nexus
Yes, yes, let it, my lord. But my present petition has no nexus regarding this offense, my lord.
a public servant committing a murder also you
No, my lord. He has not received the money.
Merely because you are public servant you have immunity.
No,
You can't do anything.
I'm not saying that is my lord. I have not
All
taken
these
the money.
things are private
All,
transaction, you purchase something, you cheated someone and all this.
no, my lord, no, my lord.
Taken cognizance, you want.
No, my lord.
wife कोची मुंह दोषी नो husband कोची मुंह दोषी नो तब दोषी किया
No. My brother is confusing. My complainant had given the money. The money was received by the Samar Kumar Mishra, the accused number one, my lord. That's who comes the
All
affair,
these
man.
things will be ascertained in the trial, sir.
Yes.
It is a cognizance. Just see, read the order of cognizance. Read the order of cognizance and tell me what is illegal.
No, my lord. Lakshmi County,
What? No, you read it.
my lord, Lakshmi County,
Read it and tell me how, what is the illegality in this.
मतलब page number 29 Lakshmi County last को अच्छी.
Last में पूरा टपड़ो.
My lord,
Read it from the top.
the case is going to put up today for hearing, page number 29.
Yes.
On the post of the cognizance as per the order dated 24/7/2023 passed by the 1cc 205 Peruch. The case regarding the 1cc the initial statement was recorded.
Initial statement of the complainant recorded in
Yes.
200 CRPC.
Yes, my lord.
Statement of the witnesses recorded in 202 CRPC during the inquiry. I have carefully gone through the statement recorded during the inquiry and the fact coupled with the allegation have constituted an offence under 320 IPC. Cognizance up to 420 IPC has already been taken in this case. So there is no need to take cognizance of 420 again. On careful consideration of the material available on record and in my opinion, there is the sufficient ground for proceeding against the accused persons, namely Samar Kumar Mishra and Vijay Lakshmi Das. And on the further perusal of the case record,
it is found that on 14/10
14/10/2020, cognizance for offence under 420 IPC was taken and summons were issued against the accused persons, namely Samar Kumar so Vijay Lakshmi Das, for their appearance. And it is further seen that on 22/12/2021, the accused Samar Kumar has appeared before the court and was released on bail. And independently, the case record was posted for supply of the PP so and so. All these things are there. What is wrong in it? You have not challenged the earlier.
Well, prior to this, petition was not to appear, and prior the initial statement, cognizance is taken. Last, my lord.
Have you challenged the earlier cognizance order?
Yes, my lord. I have challenged.
Where is that?
My lord, Annexer 1, my lord. My lord, all the things was behind me. The final report all the things behind me. When I received the notice, then my last the accused Vijay Lakshmi Das has not appeared.
Charge has been framed?
Charge has been framed.
No. I have filed the discharge, Annexer 1, my lord. For that is I come before your lordship. My last question, the Vijay Lakshmi Das has not appeared before the court yet without appearance inadvertently. The charge has been framed against the only one accused, Samar Kumar Mishra. Issue summon to the accused Vijay Lakshmi Das as a fixing 11/2023 for appearance.
Go and argue that charge. Go and argue on charge.
Charge देंगे argument.
In so far as Samar Mishra is concerned, charge has been framed. In so far as Vijay Lakshmi Das is, he is not appearing, charge could not be framed.
Last me page number 27.
Yes.
Despite the notice issued to the accused for appearance and without this court, The CP zone Kotak has supervised the case, and the 420 IPC against the Sankar Kumar Mishra. And on that day, so the Saroj Kumar Mishra has not yet replied and cheated the further open that no evidence established against the accused Vijayalakshmi Das regarding her involvement in the case.
That is why they filed a protest petition.
ସେଥିପାଇଁ ତ ଫାଇଲ କରିଛନ୍ତି ନା
No, my
Statements are recorded and then the
no,
statement.
my lord. Prior to the protest petition, cognize it again. Very clearly, ତା ପୂର୍ବରୁ 14/10 they had taken the cognizance. This is the peculiar thing. Again, the present petitioner.
କୋଉଠି ଅଛି ତାର ସେଇଟା କିଛି ଲେଖା ହେଇନି ସେ ଭୁଲ ପଢୁଛନ୍ତି ସବୁ
ଜମା ମୁଁ ଭୁଲ ଆପଣ
Say, that is the reason there is a procedure in this court to file a list of dates to make it clear. Where is your list of dates? Show me. Where is your list of dates?
Yes, my lord.
What,
Yes,
what
sir.
can you read it and make out anything out of it?
Yes, sir.
List of dates are not.
Yes, my dear sir, my lord.
Papers on the face of the court. What is this?
My lord,
Can you make out anything out of it?
କୋଉଠୁ ଗୋଟାଏ ଡେଟ୍ କୁହନ୍ତୁ କଣ କେମିତି ହେଲା କିଛି
I have filed my dear sir. My lord, I have.
Earlier you might have experienced this what is it? Telegram. Telegram you might have done all telegraphic language. See, FIR was lost, final report filed, cognizance taken, list update. What is this list update? I don't know. Merely the procedure is there. You have to file whatever you write. What is this? Read it and try to make out anything.
as per their date chart, it is well and good. As per their date chart, there is no illegality.
Nothing. Can't make out anything.
ଆପଣ ଯଦି ଡେଟ୍ ଚାର୍ଟ ଟାକୁ ଗ୍ରହଣ କରିବେ ସବୁ ଜାକ ଠିକ ଅଛି.
Let the counsel for the petitioner seek to withdraw this petition to raise all the points before the trial court at appropriate stage. With this liberty, the petition is disposed.
My lord, I have filed already discharge. I have also, my lord, I
I
myself.
know that you have filed the discharge and argue that.
My
You
lord,
are
annex
not
sir.
sure about your own thing. Anyway, next 20. Please 20.
My lord, annex one is my discharge person. My my prayer.
You argue that I have given
Trial करो
liberty.
देंगे.
Don't argue that.
ଟଙ୍କା नहीं तो ट्रायल करो देंगे.
Yes.
No, my lord, I have not received the money. My brother says that टोका नहीं चाहिए टोका. मुंह किसी टोका नहीं.
He has said anything you
No,
answer
no,
to it.
no, my lord.
I have got done my job.
My lord, I have not received the money.
I have done my job. If he is saying something, answer to him. I know. Next 20.
My lord, one date may be given. I have applied for the order of the cognizance from 9th February. One chance will
I have written an order.
Yes, yes, yes.
I have given you liberty.
And already charge is
Your
paid, my lord.
application is already pending. You argue there.
One line, my lord. I have challenged before your lordship, but discharge person charge is fixed to the 2nd April, my lord.
The liberty which I have given, shall I close it and
Already
write
liberty
a
given.
order? Unnecessary recording, so many things, and you will be in trouble. So I have given the liberty. Your application is pending. Go and argue that. That's a better course. Instead of at this stage inviting any observation from this court, it is not safe for your client. So therefore, I have given the liberty. Go and argue that. All these points are there. Yes. Item 20.
Please, Your Lordship. It's a bail jump case, my lord. The petitioner was earlier released on bail on dated 5/8/2022 by the Learned SDGM Banki.
No,
And due to
500.
And
Belgium matter. Petitioner was released on bail August 2015. And date, particular date.
He was on bail. Right now. Be careful here. Here, commit all mistakes. August, letter counsel petition submits that the petitioner was on bail and
NBW issued on 28/9/2022.
28/9/2022. 500.
Oblige.
22.
The Belgium matter, order dated 13th September 2023.
Bail,
He has bail on 26th February 2016.
26 February 2016.
Yes,
Bail, NBW 13/9/23.
yes.
500.
Prior to that, he has also bail to
500.
May please, your lords. For passing up NBW issued in 138 NI Act case.
130 NI Act, huh?
1910-2023.
NBW issued on
1910-2023.
was it? He was on bail, complete bail. He was on bail करके कर रहा था 500. 24.
At page 7, 19/12/2023, that NBW was issued. 3/7 petition was rejected and NBW was issued.
And you were on bail on?
Yes, throughout on bail. That exact information. That
Was on bail. 19/12/23.
yes, madam.
Check the record also. 500. Yes.
Next item also that 8/4/2022, that
25?
date of
25 item?
yes, date of warrant that 8/4/2022.
Bail?
That non-taking page 7. madam.
Bail.
Yes, he was throughout on bail. That exactly.
You don't have date. 8/4/2022.
22, yes. Non-taking of steps and those.
Was on bail. Okay. 500.
Apply.
26.
Bail jump, Madam Lordship. Petitioner was released on bail on 7/3/2018. Bail jump on 6/6/2023.
Bail?
Bail on
NBW issued on?
NBW issued on 6/6/2023.
Item 26.
26.
But in the prayer you are writing something else. NBW or petitioner default appearance on 7/3/2018.
7/3/2018, he was released on bail.
You are writing in the report. And thereafter you move an application for modification. Read your prayer. Read your prayer. Order of issuance of NBW against the petitioner for default in appearance by the order dated 7/3/2018. Passed in TR case number so and so so and so.
Madam, see page 7, madam. 7/3.
See the prayer, page 3. Page 3.
7/3, bro?
7/3/2018.
No, madam, turn to page 7.
But see the prayer. Prayer, what I have
Yes,
written.
prayer 7/3. I am saying, sorry, 23. Yeah, sorry. Absolutely, sorry. I'm sorry.
कुछ भी
I get it. Yes. Prefix is right, suffix is wrong.
And when you got bail, at least then.
Yeah, madam. Yes, granted bail. Madam, done. 7/3/2018.
That was the bail.
Bail.
Not NBW. That's what I was wondering.
Yeah.
Right now. Correct it. Right. Recorder correct it. Bail 7/3/2018. NBW on 6/6/2023. Okay. 500. Correct it right now. Prayer. Data change करो. Change करो. Counter sign कर दियो side. 57. Yes.
NBW issued on order dated 13/9/2023.
Yes, you are on bail.
Bail order dated 11/12/2020.
20.
20.
11/12/2020 bail NBW 13/9/2023. ठीक है 500. 28.
NBW issued in order dated 8/11/2021.
Yes.
Bail order dated 6/5/2015.
6/5/2015 and NBW 8/11/2021. 1000.
29. Content, my lord. Though this is a Belgium matter, my lord. but this is, the case is like that, my lord, the final judgment is, my lord, kept under seal cover, my lord. In this case, the judgment was already in seal cover, my lord.
Because you absconded.
My lord, the petitioner was bail on 18/3/2019.
18/3?
19.
19. And after conclusion of trial, the petitioner did not appear in the court. Therefore, the judgment has been kept in seal cover. NBW was issued on
14/9/20.
14/9/2020. The on instruction, counsel for the petitioner submits that he would be appearing before the court on or before 30th of March. Finish March. You appear before that, and NBW is kept in abeyance till then. Kept in abeyance till. Okay. Cost is 1,000. Cost is
500, my lord.
1,000. 500.
500.
500. Okay. What was the offense by the way?
138 NI Act.
138 NI. 49.
I filed an application for return of a certified copy of Annexure 6 on that last date.
49.
49. The certified copy may be returned.
Certified copy?
Certified copy of the included order TR number 19 of 20. Annexure 6 may be returned.
Okay, return.
I will substitute with
okay.
Xerox copy.
The certified copy of
order dated 10/2/2023.
Order dated 10/2/20. Imprint order dated 10/2/2023.
Passed in TR number 19 of
10/2/23, na?
Yes, ma'am.
10/2/23.
Passed in TR number 19 of 2000.
Passed in TR number.
Annexure 6.
May be returned by substituting a photocopy of the same. Password. 51.
Please. Sorry. Here, as it appears, there are some defects which have probably not been removed. So, also may allow me to inspect the file. I'll remove the defects. Otherwise, I am ready with the brief.
Defect, you remove the defect, we will get.
My lord, that's my lord may permit me to inspect the file, man.
Item number
51.
51. He has pointed out certain defects. The counsel for the petitioner seeks to inspect the record and cure the defect. Leave the matter on.
My lord, please posting it to.
Give it. Yes. 51. 51, na? 52. 52.
Let's see, item number 52, there is some defect, let's say, playing for time.
He will seek time to cure the defect. Yes.
53.
Next. 53, my lord, I'm extremely sorry, my lord, there was a mistake from our office, my lord. The requisites could not be filed within time as directed, but it is filed with some delay, my lord. So, Lordship, direct for issuance of notice, my lord.
There was some interim order?
No. Interim order माने हजूर कहते जे सेठी हम petition file करिबु से
Okay.
you will consider.
You have already filed.
I have already filed, my lord. That is the noting is there.
Requisites to serve opposite party number 2 has filed belatedly. The same may be accepted and issue notice.
Your lordship may fix up date.
Date will give.
54, my lord, I have received counter right now. They will also take it for the private. It's solved, only a short question involved, my lord. Only the, as for the notification, my lord.
You have filed the counter, right?
Yes, ma'am.
Taken on. Has it come on record? Counter? Yes, counter is there. Counter is there. Yes. Counter affidavit filed by on behalf of opposite party. Sibo Sankar Mishra. Sibo Sankar.
Passport office.
Sibo Sankar Mishra.
Yes.
Yes. Yes. Ready? Ready? Ma'am, you are also ready? No problem? Yes.
My lord, only you are also kind of glance to page 14, my lord. It's the objection letter issued by the regional passport office, my lord. There is a they stated the lordship kind of
14 of the
14 of the writ challenge. Annexed 2, my lord.
2. Okay.
A criminal case is pending against you as per police verification report, my lord. Last, my lord, Roman 2. If the criminal case is in which you are involved, then page 15, my lord.
Either the investigation stays in the police station,
Charge sheet or trial is
then
pending
you
in
are
court of
advised to submit.
court or subordinate.
Well, you want
Last
renewal of the affidavit,
Last page.
passport. Sorry.
Yes, my lord.
Renewal of.
Renewal.
What is the objection? Renewal. What is the objection? Let us see the counter affidavit. Yes, ma'am. What is the objection? Only renewal of the.
Government of
Passport.
India notification, the annexer, counter annexer B, my lord.
B. Okay.
My lord,
Here
postpone.
specific say that if any person has any criminal involvement, then the concerned magistrate should be give permission to go the accused.
Where is that? Any passport issued in terms of so can further renewed for 1 year.
Page 13
Here
of the counter affidavit.
Yes. Which provide you?
6 to F, my lord.
The central government,
6 to F.
the central government being of the opinion that it is necessary in the public interest to do so, here the citizen of India against whom proceeding
Where are you
in
reading?
para 2, my lord.
My lord, straightway, my lord, may come to the page 21, my lord. This is a notification, my lord. What he says relating.
Yes.
This is a notification. You will also kind of glance to. I have given a translated copy, my lord. I am reading.
21.
Page 21, my lord. Annexer 5, page 22, 21.
What does it say?
You stated that, my lord. Suppression of the notification of the government of India in Minister for External Affairs numbers GSR 298E.
Where are you reading?
Page 21, my lord.
21.
Page 21 is the translated copy, my lord.
English version?
Yes, my lord. It is Hindi and English, my lord.
Yeah.
Page 20, Annexer 5 is the notification, my lord.
Though
it is not clear, my lord, I have given.
Okay, page 21, which part you are reading?
Page 21, the first portion. First
Yes.
part, my lord.
The passport to be issued
My lord.
to every citizen.
My lord.
We should not.
In exercise of, I'm reading that portion, my lord. In exercise of power conferred by this by the clause A of section 22 of the Passport Act. You also got it, my lord. Notification. And in suppression of the notification of the government of India in Minister for External Affairs number so and so, dated 14 April 1976, the central government being on the opinion that it is necessary in public interest to do so, hereby exempt citizens of India, hereby the relaxation clause is given, madam. In India, against whom proceedings in respect of an offence alleged to have been committed by them are pending before a criminal court in India, and whom proceedings produce order from the court concerned permitting them to depart from India. From the
You are not leaving from India. Only you want to renew it.
No, I my prayer is like this, man.
Because passport has already been expired.
Expired, my lord. I have applied for the renewal, my lord.
Renewal has already been done.
No, my lord. During the pendency of the renewal, the objection is right.
If first let it be renewed, then after whenever you want to go, you seek permission of the court. Simple.
No, my lord. Here, my lord, what happened? Unless until the court concern will not give an order, my lord. So my passport shall not be renewed, my lord. So there is a.
I will pass an order for renewal, and after renewal, deposit it in the court. If you want to go abroad, seek permission of the court.
My lord, I can come to my petition file before the court will, my lord.
Yes. Where is that?
That is the.
This is my page 16, annexure 3, my lord.
Yes.
And a rejection is annexure 4, my lord. The relevant page, my lord, page 19, my lord.
perusal of record reveals that the petitioner is one of the accused persons against whom
Depart from India means where will you go? Nothing is there. Depart from India, you will go to Chandramanda. What is this application? Who will allow this application?
No, my lord.
Depart from India, which place, where you want to go? Nothing is written.
Right.
You are an accused,
My lord.
and you want to depart from India. Where will you go?
No, no, it is there in the my application. My lord.
Where is your application? Just see, read the application.
No, no, in the passport
What? No,
application.
no, you see the application.
My lord.
What was your application before the court? Show me where do you want to go. These kind of applications are allowed.
But
in the entire application, you show me a single word saying that you want to go to this country or that country for what purpose. I want to depart from the country, so therefore issue me the permission to renew the.
Prayer also, prayer only.
What kind of this application? Who will allow?
Lower court.
The lower court, then nobody rightly rejected. Rightly rejected. You renew your prayer.
My lord,
you give particulars.
My lord, in the coordinate bench, my lord.
No coordinate bench. This application I will not allow. No coordinate bench, no Supreme Court. We just see the application.
No, my lord. My lord, kind
you have not said a single word from which day to which day you want to go, which country you want to go.
Well, that what is, my lord. Only, my lord, it is.
Then if this application is allowed, then the police will keep on searching throughout the world.
No, my lord. That court's order, court below's order, that will affect in the application for renewal, and in that application, the court, the passport authority will allow my for purpose of renewal, my lord. Here, my lord, the notification error, you also kindly.
Why for you want a renewal? You tell me.
My renewal is because I am a businessman, and I have nexus with the outside country, my lord. Because I have invested my money in the hotel business.
Whatever.
So it is required, my lord, because I have taken the.
Whenever you want to go, you have to move application. I want to go to this country from this day to this day. Please give permission. The court will apply the principle and give you.
My lord, for a moment, my lord, can come to page 22, my lord. Annex 6, my lord. Another notification, my lord. Whenever any applicant against whom proceedings before a criminal court are pending approaches any passport issuing authority for the passport service, a copy of gazette notification for the court below, and she will allow, my lord. I will finally attach, my lord.
That
For a moment, my lord.
Application is not, completely, rightly
fresh
rejected.
applications.
You also direct, I will file a fresh application with the court below.
Let it
Where the case is pending.
Let it count, but the petitioner seeks to withdraw the present petitioner to revive its file a fresh application before the court below regarding the renewal of the passport on the basis of the notification.
Notification annex of 5 and 6, my lord.
Notification dated. What is this? On the basis of the notification dated
25th August 1993.
1993.
And my lord.
Within 2 weeks. Disposed of. You move proper application for renewal. Go step by step. First you renew the passport. Thereafter, whenever you want to go, move an application saying that from this day to this day, I want to go to this country. Please allow. Then somebody will apply the mind and give you.
Yes, second notification the kahila. Specifically.
Notification, forget about notification. What is your application?
Say application.
I want to go to Mars, you allow me.
That is.
Or I want to go to Moon, I
the court below, the advocate from the court
below. Therefore, I am giving an opportunity.
I give the
You draft it and send it.
Yes, my lord. Yes.
It's illegal advice.
Applications.
Yes.
Lordship, in this IA, we want to implead one Gajendra Prasad Bhagat as the party. So,
who is he?
He against him, the order of cognizance was taken along with the current petitioner. We have inadvertently missed the second party, like Gajendra Prasad.
The petitioner seeks to amend the cause cycle by aiding a co-petitioner. He may do so within 2 weeks. These two matters. Yes.
Lordship, press constable we have.
Yes.
56. Maybe. On behalf of Mr. Janna, my lord, in order dated 19/1/2024 passed in 3 CLMC 3 of 24, my lord. In third paragraph, my lord has set aside the order dated 11/12/2023, the issuance of NBW, and directed the petitioner to surrender before on or before, my lord, 15th February, my lord. The petitioner has duly surrendered. But my lord, the learned trial court insisting to deposit 4,50,000 as per, my lord, that order, my lord.
But I have not said 4 lakh.
My lord,
Only 500.
my lord, kindly have a glance to running to second paragraph, my lord.
Yes.
The petitioner filed seeking. My lord, earlier, my lord, the petitioner had moved anticipatory bail, my lord. And in that order, my lord, 4,50,000 was.
That was the precondition you have to comply. What to do?
My lord, she's a lady, my lord, she's unable.
Lady or whatever. You have got the bail. You gave the consent that I'll deposit 4,50,000 rupees. You didn't deposit. NBW was issued. You came here.
Yes, my lord.
I said that, okay, you go and appear. I am cancelling the NBW. But bail condition has to be complied.
That
bail condition, what can I do?
My lord,
If the court is insisting, rightly insisting, because it is the order of this court that you shall be released on bail after depositing 4,50,000 rupees.
Yes, my lord.
You don't deposit, what to do?
If, my lord, that
Or go and move in that court and ask for variation of that order. I can't vary that order.
Yes,
That
sir.
coordinate bench has passed. You moved appropriately.
Yes, my lord. Permit.
Withdraw.
7.
My lord, I'm appearing for opposite party number 2.
Opposite party number 2.
Yeah, I'm for the petition. Notice issued and appearing there.
And so entering appearance for opposite party number 2. File the Mokalatama. It will be taken on record. These matters from the entry of the fund. Yes.
58. Lordship disposed of the CRLMC, but there are certain developments for which I filed an application for recall. My lord, I'll bring those developments, that charge sheet and all, before your lordship. Your lordship may adjourn this matter to 1 week after.
Yeah, what was the order allowed?
Yes. Your lordship was not inclined to interfere in 319 application, which was allowed. 319, initially I was not charge sheeted. I was not named in the FIR. Charge sheet was also not given in my name. Subsequently, when the evidence was going on, one of the witness stated about my name. 319 power was invoked by the court.
Now, I have only said that at this stage I will not.
Yes.
Because there are development.
There are developments in which the final charge sheet has been given, or in which also my name is not there. And there is a judgment of the Hon'Ble Court which I have got it. I'll bring that on record so that your lordship may reconsider my application on that line.
No.
Subject to what your lordship.
After I pass this order, there are some development.
There is a development that the final charge sheet has been
filed.
Given.
So therefore, your modification application I am allowing to the extent that you will be filing a fresh substantive petition. Bring it. Because modification on the basis of changed circumstances may not be possible. So you seek the liberty to file a fresh
My lord, pass this order. My lord may kindly see my lord's order.
Taking into consideration the nature of allegation against the petitioner and the peculiarity of the present case, the petitioners are protected for 6 weeks, so as to enable them to surrender before the jurisdictional court and seek appropriate remedy available to them under law.
My lord, here what has happened by this allowing 319, he has taken cognizance, everything he has done on 319%. And it simply I am to be arrested.
That would be a fresh cause of action. Why don't you file a fresh petition?
Your lordship may give me some protection. I'll file a fresh
protection. Is there already?
No, 6 weeks is ending tomorrow. 6 weeks is ending tomorrow.
You are asking for extension of time then?
No, I want that in the final charge sheet, which has now been given.
Where is the modification application?
My lord, modification is 570 of 24.
The petitioner has filed a application for modification of order dated. Order dated.
It's 8/2/24.
24. On the ground that there are certain development which is taking place.
Final charge sheet has been given now.
Certain development which is taken place. And by the order dated 8/2/2024, 6 weeks time was granted to avail appropriate remedy under law. 6 weeks time is going to expire tomorrow. So therefore, he seeks further 1 month, further 1
Yes.
month time. Taking into consideration the amendments made in the application and the fact that there are certain developments, the petitioner is granted liberty to file a fresh petition if so advised, and the protection granted to the petitioner by the order dated 8/2/2024 is extended for further 1 month. You file.
Well, I'll file before the learned court.
You do whatever.
Your lordship may only say I'll move the.
I gave the liberty. You file fresh cause of action. You file a fresh petition. The only thing is, 6 weeks time I had given. I make tell.
Grateful.
May I please, Lord? My lord, here petition is a 22 years young boy, my lord. Inside custody, my lord, 6/4/2021, my lord.
Is the bail matter?
No, my lord. It's a he had moved application under 91 and 311 petition, my lord, which was allowed, my lord, but subject to deposit of 5,000, my lord. He is in custody since last 3 years, my lord. It is not, my lord, that condition may be only to waive out
What are the offences?
It's a 21B C of NDPS Act.
21?
C of NDPS Act. He is in custody.
Recovery? How much recovery?
My lord, no, more than, my lord, some 280 grams of some brown sugar was seized.
Where is that condition?
My lord, running page 7, my lord. Deposit and within last, my lord. The cost of 5,000.
Defense has wanted to prove so in the technical payment of cost witness cost. It is in your application.
Yes,
you moved the application.
Yes, my lord.
Well,
5,000 rupees.
5,000. It's not that 5,000 is going to make much of a difference either way.
But he is in custody since.
Well, that's so I'm saying in his favor.
Because he has right. The petitioner had moved an application under 311, seeking recall of which witness?
My lord, a witness that annexed to my lord, a witness bearing to prove the accused logbook.
Which PW?
That is not mentioned in the.
You should know, na? It is not mentioned. That is why I am asking. Where is that?
My lord, Sunil Kumar Biswal, one driver of the vehicle, my lord.
Application before the trial court, seeking recalling of a witness, prosecution witness, which was allowed by the court below by the order dated 29/1/2024, and directed the petitioner to pay rupees 5,000 as witness costs. Witness cost. The petitioner submits that he is in custody since last
6/2021.
Custody since 6/4/2024 because of
21
because of the cost imposed on him. He is not able to conduct the cross examination of the witness recall. Why the order dated 29/11/2020. Hence he seeks indemnity. The order dated 29/1/2024 passed by the ADJ, first ADJ, come Special Judge Khurda in TR case number 21/21. Is modified to the extent that the payment of cost of 5,000 rupees as a tentative witness cost is waived, and the petitioner shall be allowed to cross-examine the witnesses, sought to be recalled to the application we had moved to the court consider. Yes.
Pardon to make a mention.
I'll immediately take immediate order. No, 3 o'clock.
It will be a pleasure to address your lordship after lunch.
No, the same matter.
No, different matter, different matter.
In fact, I hope your lordship is well today because yesterday we were there.
I am not fully well, but because looking into the urgency, I am only told them not 3 o'clock because it is already 60 matters.
We are here. In fact, there is good news for the government also. The director has himself come down. He is present in court. He is willing to cooperate with all that they want. Just if my lord would protect him, he's here in court today.
That's fair enough. We'll do it.
Yes.
Pardon
We want to actually get things going.
That's the whole idea.
Yes.
That's the whole idea.
He's very cooperative. He will abide by any direction, your lordship. He's here present. After lunch also.
Pardon to make a mention, my lord. I pass item number 4, your lordship has passed it over. Can it be taken over next week, my lord?
He will give you date. Don't worry.
Oh, bless you.
Which is your matter?
Yes, I'm in item 60, the next one. I'll address your lordship after.
It will take time, or else shall I do it? In court?
No, lordship may proceed for lunch. We'll come. No.
Item 65.
In the order of cognizance dated 1/5/2023, your lordship. The cognizance taken under section 493, 417, and 506 of IPC, your lordship. Meanwhile, the parties have been amicably settled and compromised between each other. We have filed a joint affidavit.
490.
417 and
506.
What are the allegations?
My lord, the allegation, my lord, the petitioner and the complainant are the uncle, my lord. And she was staying there with the petitioner, my lord, while pursuing her studies, my lord.
Have you seen?
Yes. Yes.
No problems.
Yes.
They're present, my lord.
Kausalya and
May I please, Your Lordship?
item 3.
Again.
Yes.
On behalf of Mr. P.K. Raut, after 1 week.
Urgent. Yes. Item 10. 10. Urgent. Item 30. 30. Yes, 30. Yes.
And the petitioner is in custody since 10/8/2023.
Yes.
And case is that charge sheet has been submitted under section 341, 294, 323, 324.
What are the allegations?
Allegations, my lord. The infant sister Nandini Mandi had married to accused Nrsinghanath Mahanti from a silver. After some days of marriage, he had started torturing to her. He started torture to her. For which she was staying in the house of the infant due to torture. Always the husband Nrsinghanath Mahanti frequently threatening his younger sister by coming to their house. Meanwhile, his elder brother-in-law staying in a neighboring village with his family members since last 2 years for study of his children. On 8/8/2023, at about 11 p.m., accused Nrsinghanath Mahanti by coming to their house had abused them and had threatened to kill them. On 9/8/2003, his wife had informed in the PS in the morning at 10 a.m. 9/8. Thereafter, at 3 p.m., the informant and his family members, including his nephew.
What is the role of this petition?
But this petition, my lord, what happened in this case, my lord, on the date of alleged occurrence, the Nursianath is the main culprit, man, who
He is Kashinath Mahapatra.
Kashinath Mahapatra, another my lord, the
Second
Punali
case.
is Raghunath Mahapatra. They are the brothers of the main accused, main assailant,
Nursianath.
Nursianath, my lord. What happened in this case, my lord, on date of occurrence, when the mother of the deceased and father of the deceased, my lord, they went on the way, he started assaulting by means of knife to the neck of the deceased. How did he fell down one? When he cried for help, my lord, by the time these petitioners foretold the father of the deceased, my lord, who was also the Nursianath also assaulted them by means of
Investigation over.
Over, my lord.
Charge sheet filed.
Charge sheet filed, my lord.
In the charge sheet, how many accused are there?
There are
Four accused.
Four accused persons, my lord.
All of them got bail.
No, my lord.
No, man.
Principal accused behind bar, my lord. So, for this petition is concerned, there are allegations, my lord. They have assaulted to the father of deceased, my lord. He sustained severe injury, my lord, and admitted at hospital, my lord. For that reason, coordinate bench directed the State Council to obtain the instruction regarding health condition of the Sukant Pradhan, my lord, father of the deceased, my lord. And 3 injured persons are there, my lord. These petitions are, though not assaulted to deceased, my lord, but assaulted to the injured persons, my lord, Sukanta and 2 others, my lord. And the health condition is not well, so far the Sukant is concerned, my lord. And what do you think? Instruction, my lord.
He has already discharged from the medical since 13/8/2023. And can you see the discharge certificate?
Discharge there, but I read out the
discharge certificate. ଦେଖନ୍ତୁ ଆଗରୁ
9/8/2023 ରେ କୁମ୍ଭାରପଡା ଥାନା ତଳ ସାହି ନିକଟରେ
10/8
ନୃସିଂହନାଥ
ରେ
ମହାନ୍ତି ତାର 2 ଭାଇ କାଶୀନାଥ ମହାନ୍ତି ଓ ରଘୁନାଥ ମହାନ୍ତି ମିଶି ମୋର ପୁଅ ସମରେନ୍ଦ୍ର ପ୍ରଧାନ 7 ବର୍ଷ ସଂଘବଦ୍ଧ ହୋଇ ଛୁରୀ ଦ୍ୱାରା ଆକ୍ରମଣ ହତ୍ୟା କରିଥିଲେ। ମୋତେ ମଧ୍ୟ ଛୁରୀ ହାତୁଡ଼ି ଦ୍ୱାରା ଆକ୍ରମଣ କରି ଗୁରୁତର ଆଘାତ କରିଥିଲେ। ମୋର ଅନ୍ତବିଜୁଳା ବାହାର କରିଦେଇଥିଲେ। ସେଇ ଦିନ ଠାରୁ ଗୁରୁତର ଆହତ ଅବସ୍ଥାରେ ଭୁବନେଶ୍ୱର
Statement of
ସୁକାନ୍ତ ମ୍ୟାଡାମ
ତ ଅନ୍ତର୍ଜଳ
report direct to the State Council to obtain the instruction.
that is the order.
My lord.
The accused Nrsimhanath Mahanti.
He is still in the hospital or what?
No, my lord.
I have given
What was
the
the injury? What was the injury to this Sukant Pradhan?
Sukant Pradhan, there are injuries.
Medical report is that you have?
My lord.
Just see. Injury report.
My lord. 3 injuries, my lord. I have folded all 3, my lord. Wife of the Sukanta and
You tell me what is the.
my lord. There are a total 4 injuries, 5 injuries.
Simply or grievous?
My lord, grievous injuries are there.
Which part of the body?
My lord, scalp, my lord. Scalp, head injury there, and also, my lord, belly down. Belly report ଅଛି belly ଗୋଟେ ଆଉ scalp ଗୋଟେ
ସେ belly କି ଆକି ନୃସିଂହନାଥ ମହାନ୍ତି ଆଡା
right flank ରେ ଗୋଟେ other injury there, but abdominal injury ଗୋଟେ
and on the assault of ନୃସିଂହନାଥ ମହାନ୍ତି
and back ଗୋଟେ ଅଛି over right.
Sukanta Mahanti is the injury report.
5 injuries.
You have
all
assaulted Sukanta Mahanti. These are the injury reports.
Not only these petitions assaulted Sukanta Mahanti, but also assaulted 2 of the lady members of the family of Sukanta Mahanti. They also suffered injury. And also, my lord,
April 1st week report.
These petitions would have not restrained the Sukanta Mahanti, my lord. The disease must have been, my lord, survived.
April 1st week. Yes. Next.
32.
April 1st. 21B of the NDPS Act.
How much?
60 number of cough syrup.
Cough syrup?
Well,
16 bottles.
60.
60. Custody since?
Your custody since 13 November 2023.
12 grams. 13 November?
2023.
Medical exam, chemical examination report just
12 grams of
12 grams. Look up 60 bottles of cough syrup containing
12
grams
codeine phosphate.
sodium phosphate.
My lord.
12 grams, huh? Granted. Okay. Yes.
35.
I plead your lordship.
Yes.
Let's see, here the petitioner is in custody since 30th September 2023, having been implicated under section 302 of the IPC. The allegation is that it's a dispute arising out of a distribution of a bamboo cluster. And what has happened, the deceased, having seen the cutting of bamboos by the present petitioner, protested, and there is a hue and cry and exchange of words, and the petitioner stabbed the husband of the informant by means of a sharp edged cut bamboo. Meanwhile, charge sheet has been submitted on charge sheet has been submitted on 23rd January 2024, and 302 is the offense, and charge sheeted on 302.
This order dated 18/1/2024.
Yes.
The coordinate bench says that considering the nature of allegation against the petitioner, I am not inclined to release the petitioner on bail at this stage.
Charge sheet, I have stated that charge sheet has been filed. I have to produce the charge sheet. That is why
Petitioner
kept
submits
it.
that since the charge sheet has been filed, he wants to go through the charge sheet, and
Yes.
there is an express of opinion that no bail shall be granted. Charge sheet, where is charge sheet?
Charge sheet, actually, one other. Charge sheet.
You file the charge sheet then. You
That's-
got time.
Yes, yes.
You file the charge sheet. File the charge sheet. File charge sheet, let it come into April first week. Okay. You sought time to file charge sheet, you file the charge.
Yes, sir. I'll file it.
Next.
40.
The petitioner has been falsely implicated under offenses under section 376, 354, 384, 506 with section 67A of.
What is the allegation?
Last occasion, 164 statement call for.
And there was a counter case, and the previous rivalry was there. Because of the previous rivalry, the case has been transferred like this, and the petitioner has been implicated. I have also annexed the complaint case, that complaint petition. I had annexed to page 18, where I have it reveals that there was previous rivalry with regard to self-help group or loan transaction, and the petitioner, the victim, the informant, was used to travel along with this petitioner long distance for to bank for securing loan, and there was intimacy, and because of
what is the allegation against you? Tell me first.
Allegation that while traveling along with the petitioner, the victim says that she has been
If I may, my lords, the allegation, the primary allegation is that there was a non-consensual rape that has occurred. Secondly, that he has recorded certain videos on his mobile phone, and now he's threatening to make those videos viral. And
what to do? Have you seen it?
No.
That's the problem. Yes. He doesn't want to come to you. Tell me now.
But your lordship, kindly see the 164 statement. 164 statement clearly shows that it is a dowry demand case only.
Where is 164?
Your lordship, kindly see. Certified copy of the 160. Earlier in the 2001, there was some love affairs between them, for which there is relationship between themselves, but that came to an end in the year 2021. Subsequently, in the 2023, they married. She resided in the house of the present petitioner for about 8 months, and due to demand of dowry.
You bring it on record, we'll see.
My lord.
Bring it on record. The written instruction received from the IIT, na? Written instruction.
My lord.
The court copy. So is taken on record. Then consider the petition 6 times to file additional document to substantive the case. First week of the yeah.
Oblige.
Yes.
43 is OPID, my lords. This is that matter which I was arguing before your lordship. My lords, if, my lords, we are dealing in cryptocurrency, my lords. That has been held to be illegal. It is an international currency. It is like, it is legal. It has been held to be legal by the Supreme Court, my lords. The RBI has only issued an advisory guideline, say if you are investing in cryptocurrency, it is at your own risk. ERW. And so, my lords, if I've given your lordship the judgment and your lordship has also formulated a question on the last occasion, my lords, I'm just reading out the relevant portion of the RBI of the judgment of the Apex Court. At page 173, my lords, we had given the judgment.
Yeah.
May I place it, my lords?
Yes. What I'm submitting, Miller. In this case, to just now I have obtained instruction, Miller. Today, cash is going to be filed, Miller. Let it come any day, Miller. In the meantime, we will obtain the cash copy.
Monday,
response for the respondent submits that charge sheet is going to be filed today during the course of the day. Therefore, he seeks an adjournment. Adjourn to everybody next week.
Monday, my lords.
18.
Oblige.
So give a copy to, in any case, he's entitled. Give a copy.
Let it come,
18.
18.
Little bit of time for that.
My lords, because I would not have objected. Well, it's found to be legal. And he is dealing in cryptocurrency.
Anyway, now charge sheet has been filed. Now you have a much stronger case. No custodial interrogation is required. It is
19.
21st, he says.
Oblige. My lords, it will be better if it is on the 19th. 20th, 21st, I have some difficulty. 19th?
No, only Savana ticket little.
Acha, ठीक. Oblige.
20. No?
Whatever. 1 minute. IAC Ambarola, kindly open your video.
May I please?
Yes.
Here, my lord, allegation initially on 490.
Mr. Bhuya may be reflected in those cases.
Bhuya's name should be reflected.
Initially, my lord, FIR was lodged 498 along with other offences, my lord. Subsequently turned to, my lord, 376 2N and AB, my lord.
Yeah.
There is a case that allegation in 3 phases, my lord. Allegation is that 5 years from the date of occurrence, my lord, the allegation is that the petitioner has taken forcibly to the victim and committed sexual assault. There are subsequently there is a village meeting that.
No, your in the cause list your name is there, but in the order sheet, Mr. Maharaj's name.
No, my lord. I am earlier. I am appealing for the petitioner.
Petitioner comes in
Earlier. Okay. Name of Mr. Yes. Yes.
1 week time, let's see, file a requisite, my lord.
Okay, file 60. Yes.
May it please, my lords.
Yes.
Pick and facts here, my lords. The petitioner is no way involved in what has happened. My lords, the
Parting
FIR
of the entire proceeding.
My lord, yes. The FIR story would reveal that one Ashok Kumar Das files a complaint before the police saying that his wife had purchased a car from one Devi Prasanna Padi. Devi Prasanna, after purchasing the car by paying 8 lakhs something, they came to discover that the car has a outstanding loan of some amount, 6 lakhs or 8 lakhs or something with the ICICI Bank. That was suppressed by Devi Prasanna Padi while selling the car to Sushmita Das, the wife of Ashok Kumar Das, the informant.
Who are you?
I'm coming to that minutes. Now, after they discover, they go to Devi Prasanna, return the vehicle and return the papers, saying you give back my money. So Devi Prasanna doesn't give back the money. Then they go to the RTO to cancel the registration. When they go to the RTO, they find that the car is registered in my name. That is the petitioner's name. The car has been, my case is that the car.
Who had taken loan from IKT?
Maybe Devi Prasanna Padi. I have no idea. I have no idea. I have taken it from Tata Finance on refinance. I have taken the vehicle from Tata Finance for 6,50,000 on refinance. And I have paid back the entire my lord's loan. And your lordship may kindly turn to my lord's.
What is the FIR then?
FIR is, they went and when they informed about the thing to about the fact that this has been done by Devi Prasanna Padi, they informed me. Then I said, look, I have bought it from Tata Finance. You do whatever you want to do. I am nowhere connected with this. Now your lordship will see.
When have you purchased after what? During what time?
I have the entire 2008. The entire documents are here, my lord. Annexure 3, page 20, your lordship will see. Page 20.
Where is the vehicle now?
With him.
No, you only.
No, I have disposed of thereafter. I have cleared the loan and then disposed of the vehicle. I have cleared the loan. Tata Finance, no dues. They have given me no dues. Then I have disposed of the vehicle. That's not with me. Now your lordship will see page 20. I am a bona fide businessman. I run, I have a huge business. Why should I bother for this 7-8 lakhs or 3 lakhs or 4 lakhs, whatever, my lord?
Yes, Mr.
20, page 20.
Somebody else was purchasing the car. Somebody else paid the money. And he is the owner.
The petitioner is the relative of the original owner, my lord.
Only that is enough.
The informant one came to ask office.
It's a matter of 6 lakh rupees only.
Why should I bother about that? My turnover is few crores.
Who will issue? Have you issue notice?
No, everything is over in the last stage, my lords. Your lordships were about to, the coordinate bench was about to quash it. Then they said, we'll hear Tata Finance because the documents I have annexed is Tata Finance's no due certificate.
Who is appearing for the opposition?
Tata Finance,
Tata Finance, I am appearing.
Page 20.
Who is the informant?
Informant by
OP2.
Ashok Das. No, he has notice has gone, he is not appeared.
No,
He is
no,
not
opposite
appeared.
party, there is no opposite party here.
Yes, opposite party number 2.
Ashok Kumar Das.
Ashok Kumar Das is the informant.
Notice has gone, he is not appeared. Even by special messenger notice was sent, he is not appeared.
You are Pujari.
I am Pujari man.
But in my it's not there.
Page 20, your lordship will see, I gave a mail to Tata Finance, said that all this is happening.
You are for Tata Finance.
Yes, my
What do you
lord.
say?
My lord, the wife of the informant was the owner. And it was
There could be only one owner.
My lord, only
He
one
is
owner.
owner
My
of
lord, the informant is no way connected. And Devi Prasanna, he is not coming forward to lodge any affair, nor ICICI Bank. Informant, why he has lodged the affair, it is also not known, my lord. Wife of the informant, he was the owner. And he
What is the
sold the vehicle to petitioner.
and got the money.
So they have filed the charge sheet, my lord. The entire sheet is not with me, my lord. I will obtain the SCD.
We'll quash it if nobody is taking.
Yes, my lord.
They have no problem.
We have received our money.
Their interest is only money.
We have received our
No
money and
dues,
it was
no,
sent.
everything has been annexed, no dues achi.
And informant is no way connected.
No.
Informant is neither owner of the vehicle.
I am not.
Nor his wife was the owner of the vehicle. He sold the vehicle to the petitioner, got the money from the my lord bank, and thereafter petitioner.
That dispute.
My
I
lord.
am no way connected. I am a bona fide owner.
Get the SCD, will quash it.
They be person party, my lord.
As
the
against
the
me,
wife of the informant, my lord.
was.
But Ashok Das is the informant.
Yes, my lord.
But the Devi person party sold the vehicle to the wife of
Ashok Das.
My lord.
Ashok Das is not interested now.
No, my lord.
He is not coming forward.
Notice has been sent. Notice is sufficient. देखी देते हैं क्या? दीदी थोड़ा notice जाइए twice. Twice notice जाइए. He has not turned up. And in fact, my lord, if something like that has happened, the natural flow of events, I am the victim. I'm not I have taken it on refinance from Tata Finance.
In fact, my lord, during course
And my friend is saying that is true.
They did not cooperate.
That is true, and I still will face the charge. Try.
My lord, all two of the accused persons, that party and also the Pujari, my lord, they are related to each
Why
other.
should I be bothered in this
And
kind
when
of a
the
thing?
person came to know,
You are on bail.
no, my
No,
lord,
no,
they are
I
after
am
that.
no, I am protected by your lordships. I am on bail. I am also on bail.
But the charge sheet shows that they have filed charge sheet, my lord. Both the accused persons are absconded.
And the Tata Finance writes at the time of financing, the vehicle was free as per our verification on the RTO records. There was no
Then why don't
hypothecation.
you file the application for discharge?
Again,
Charge
this,
sheet has been filed.
again,
Cognizance has already been taken.
charge sheet. I was paying a quashing of proceedings. I am no way involved. Why
These
should I?
things can be seen at the stage of charge only.
Well,
I will simply
on the
observe that.
My lords, on the face of it, it is not maintainable. On the face of it, the coordinate bench took a view that we'll only listen to Tata Finance and then
Then
pass
in
orders.
that case, I'll have to look into the charge sheet, entire charge sheet.
Again, definitely, am I against it? There's nothing against me. Even if your lordship goes to the entire charge sheet, there'll be nothing else more than this.
So that is the test.
My lord.
If the charge sheet is taken at its face value, if
That
nothing
is
is
the
paid
test,
out, then
that
it
is-
is cost.
Yes.
So let us see the charge sheet.
My lord. Your lordship-
Where is the charge sheet is filed? On record?
They have filed page 15, my lord.
15.
During course of investigation,
Entire charge sheet is there.
spot was visited, complainant and witnesses were well examined. They proved the occurrence, seized documents from the ICCI bank and active BBS of Bhubaneswar, presence of the witnesses by Ridenayo. After a transfer, the handwriting method, you'll see.
You read it and assist me if any case anything is made out, it's all right.
But for that reason, my lord, 161 is required, my lord. That is not with me. For that reason, my lord, another written may be given, but if the front not appear, my lord, then state.
See, there are two options. Either the entire thing has to be there because many things it's not legible at all. 161 statements are not there.
My lord.
And
Other documents seized during course of that is
what are the
required.
documents seized? How can
That is required, my lord.
those documents are relatable to you or not? That has to be seen.
Lordship may only
Or
turn annexure 3.
better would be you argue all these things at the charge stage. Move an application, I'll give you liberty. Or everything will be there, you can point out. I'll protect them till then.
No, I am already on bail. I'm already on bail.
You are on bail, you have to argue all these things.
Bail.
So you ask for
Bail,
no, you charge sheet shows you are.
go on bail.
I'll record it. You are.
No, I have surrendered. I have gone on bail.
So then argue
Both
all
of
these
them.
things on.
That's why I am on quashing. That's why
For quashing, the entire charge sheet has to be there.
I filed the charge sheet.
No, the 161 statements are not there. What are the documents?
Final form 14.
Everything is have to be looked into
14 to 19.
at this stage.
I'll make a chart to assist your lordship, my lords. I'll come with a chart.
Better course would be to argue there, move an application, argue. I will give full liberty to you.
My lords, my
And
most,
you revive if you.
my lords, my most humble and respectful submission before Lord. My lordship is taking a view, my lords, I'll not. My most humble and most
I'm
respectful.
not taking a view, I'm just.
What has fallen from your lordship?
Suggestion.
Falling from your lordship, my lords. Well, this is a case where I am the victim. I am crying hoarse, my lords, before all the courts that I am a
Absolutely
victim.
correct.
I have,
I am also, from say, have the same view.
my
But the
lords.
problem is, since charge sheet has been filed, I have to look into the entire charge sheet
My lords.
along with the documents.
My
Whether
lords.
prima facie case is made out or not has to be seen.
My lords.
Cognizance has been taken.
My lords.
So better course would be you get better audience there before trial court at the charge sheet.
My lords, why should I again face the harassment of facing a charge when the case is false? I'll go by 2012.
Tell the court, don't frame the charge.
My lords, if I go by the standards of 2012 Supreme Court, my lord, that judgment, if it is taken on its own manners, on own merits, a charge sheet, why should I unnecessarily go and face the harassment of a trial? My lords, I have to
Then you
stand firm.
file all documents, it has to be.
My lords, I'll file it.
You file the all document, it has to gone into. If that option you don't want to exercise,
Again,
then
let
I'll
them-
have to look into
my
the
lords.
charge. That's the.
Enter police paper.
You, let them file, the entire, you bring.
କେବେ ଆଣିବେ କୁହନ୍ତୁ ଆପଣ? ହଁ, ଗୋଟେ date
If
କୁହନ୍ତୁ, ଆମେ-
there are some documents which are not at all legible,
Again.
just show me so that if no case is made out, we'll cause it.
Again.
Okay. Give a date.
କେତେ?
First. Great. Interim order to continue.
61.
Interim order to continue. And you also just, if they can't file it, you
My lords,
file it so that
I'll obtain a charge sheet also copy.
charge sheet and 161 statement.
Grateful.
Presence of opposite party member 3 may be required.
Yes. Opposite party. Yes.
My lordship.
Next. 61.
Lordship, Senior Counsel, Mr. Shantanu Kumar Sharma will argue this matter. Today, pray for adjourn.
Last occasion also, same thing.
What to do? What to do? Interim order is there?
No.
No interim.
No interim order. is there?
No interim. First week of April, my lord.
Yes.
Deeply honored.
Adjourn.
I am appealing for the opposite party in complainant, my lord.
62?
My lord.
Nobody is
Matter
appealing.
matter has already been infectious charge because the case is posted for argument, my lord.
I adjourn it to May.
May I please your lordship, my lord? May I please your lordship?
May I please your lordship?
May I?
My lord, I am for the informant in this case.
Hmm.
I have filed an IA at a flag mark B for the vacation of a stay order dated 25th August 2023.
Yes.
My lord, in this case, there is a dispute as to the identity of the dead body of the deceased.
Yes.
The petitioners in this case allege that the dead body is not the dead body of my son, that is informant's son, but there is a DNA report. Already I have annexed. Kindly see annexure to page number 6, which clearly stated that
But petition counsel is not there, my lord. Last occasion, he stated before the court that one day discharge petition are also the charge cannot frame. Mr. Tripathi was arguing. You don't say urgency matter, saying
Interim order. No, problem is they take interim order and don't come to the court.
not today.
That's the problem.
my lord, there are 36 witnesses, charge-sheeted witnesses, which are to be yet examined.
See, the problem is interim order is given by a coordinate bench. I have not seen that interim order. But keep it for tomorrow. tomorrow. If he doesn't come, I'll vacate the entry. Tomorrow, huh? If he will not come, then I vacate this entry.
May I please?
Very liquid over even after second call, the petitioner will tomorrow.
May I please, your lordship, my lord? Pardon to mention, my lord. Item 62, my lord. I am appearing for the petitioner, my lord.
It is already urgent.
Already urgent, my lord.
Yes. No, not 3 p.m. They are there.
ଗୋଟେ ରହିଛି ସେଟା ସରିଯିବ
ଆଉ ଗୋଟେ କରିଦେବେ 65 ଅଛି ନା ଆପଣ କରିଦିଅ ନା
ସେଟା କରିଦେବି
Pardon to mention, madam.
66
Pardon, madam. Item 63. Permitted to withdraw, my lord. Item 63.
My lord, vacation order be. My lord, time period be fixed for the conclusion of.
In each petition you want relief.
My lord.
You have not come to before. His petition is withdraw. Where?
67.
Nobody is there. Urgent. You are
I'm for the opposite party.
Nobody is there.
Maybe you have the petitioner.
No, sorry, I'm for the petitioner. I'm sorry. Petitioner. The opposite party is not here actually.
Opposite party absent. You will
Absent.
kindly taken up some other day.
You are enjoying interim order. Therefore, you forgot. Okay.
Interim order to
Continue.
Deeply please. I'm sorry.
68. Yes.
My last occasion, my lord has been pleased to issue notice to the opposite party.
Yes.
My learned friend is appearing for the opposite party.
Yes. What
Here,
you
my
want?
lord, passing the order of cognizance. But fact remains in the meantime, but it reveals from the FIR and all other stories. If at all it can be sent for a conciliation because family dispute.
What do you say?
My lord,
I think
I leave it to my lord.
I don't leave it to me. You settle
My
it.
lord, kindly have a glance. This is a peculiar case where father-in-law assaults the daughter-in-law. My lord, kindly have a glance to page 14.
Tell me. What?
If my friend speaks, I leave it to my lord.
Try with the matrimonial dispute. Go and try and finish it up.
Today morning, I have ascertained from my client, there will be no question of settlement.
Mediator will call you.
Mediator will call.
I may protected.
Why to precipitate? I'll
My lord,
protect.
Madi,
Once things will be precipitated, then there will be no mediation.
my lord, since 2023, they have taken 10 adjournments on the ground different. On so one accused deal, another counsel state that I have not received the number. That is the order sheet.
No
But
court
the-
action shall be, no court action shall be taken against the petitioner during the exploration of mediation. Before mediation.
Yes. Deeply.
Only for that.
For this purpose, obviously.
My friend,
Nahi, with all expectation that good sense should prevail.
That is
Either of the way,
that is
they want to settle the matter under one roof or else otherwise.
during recess,
Decide in the.
I observe.
Yes. Thank you.
during recess are discussing either they may remain in one group or be separated.
Right. That is the only thing. And
My learned friend is in the other side.
Okay, next. 66. Okay. Yes.
Number there are two matters. 66 is regarding that summons to a direct. On his own, he has traveled from Vietnam. He's willing to cooperate whatever they want.
Mr. Party, now
Let them order and go. Let them appear.
No, my lord, why not they protect us?
One way they are
Only-
challenging, yes.
No.
Other way they will say that.
See, I'll tell you, if the apprehension is there in the mind, he can't free and frankly appear before you. and answer your queries also.
My lord, it is.
Before the
very
learned
clear
DSG,
that
He is here. He is here. What I'll do is to strike a balance. You will not take any coercive action against him. If at all you will take, give 1 month notice.
Yes.
Give 1 month.
Right. And your lordship may keep this pending. If they are not happy with us, they can come
No,
back.
if they will give you notice, 1 month notice, then in that case you avail the remedy.
But only thing is because
He's there, you now interrogate whatever you
Or
interrogate.
his coming appearance is all right, my lord.
He's coming.
Lordship may see the summons for a moment, page 60.
60?
Page 60 of this page, what they have annexed.
Okay.
Service of summon notice and judicial processes. Then
Let us not go into
clause
Mr. Patil, let us
4.2.
not go into it. Let us proceed further.
That 1 month transit period for which I am enlightening my lord. Suppose there appear, my lord is protect him, no coercive action.
No, I'm not saying. I'm saying that in case you want to take coercive action, give 1 month notice.
Yes.
You may not take also. It's not necessary. You will not take. Even if you want to take, give notice so that they explore their remedies.
Yes.
Due process of law.
Whatever process of law, whatever process of, at least right. He
is appearing here also. In person, he is there.
Is there? I will record it. I'll record it. The petitioners have challenged the summon order. What is it?
The summons to appear.
The opposite party have issued summon for appearing before the investigating officer on wide summoning order dated 26 December 2023. 2023. The petitioner has assailed the said order in this petition.
61, 62.
The petitioner is present in the court, being represented by his counsel. Mr. Mishra, senior counsel appearing for petitioner, submits that since the petitioner is in India, he would appear before the investigating officer as and when the investigating officer calls him. You tell me when he will appear. Tomorrow?
Within 3 days, I don't know. Actually, I don't have any instructions.
He is there, no? He
is there. Like yesterday, I intimated my learning.
The problem is there. What will happen is he will keep on waiting and he will keep on waiting. You don't call. Well, once he leaves, then he will start moving up. This is this.
What I am suggesting, my lord. Lordship may give this department to within 3 days. He may.
Okay. Okay. Right. No. Also, the present in this court, represented by the counsel, Mr. Mr. and senior counsel, PS for appearing for the petition submits that his client is ready and willing to cooperate with the investigation as and when he is called. Mr. Padi, Deputy Solicitor General, submits that within 3 days the investigating officer would be summoning the petitioner to appear before the IO and record his statement. To allay the genuine apprehension of the petitioner regarding the coercive action that might be
regarding error.
Coercive action that might be taken against him. He prays for indulgence of this court. In the event, the investigating agency find it necessary for taking any coercive action, the investigating agency shall issue prior 1 month notice to the petitioner, so as to enable the petitioner to avail the appropriate remedy under law.
Yes.
Under law. You give a notice if required. It may not be required also. Who knows?
Yes.
So that at least 1 month he freely can take the remedies. And what about the other
matter, my lord, may see the revision which they have filed. They are giving an order of the coordinate bench here. Now, they have filed a revision against release. This is only against the conditions. The coordinate bench order we are giving, my lords.
If
My lord may-
the release order goes, everything goes, and if
My
the
lords-
entire order is
My
there,
lord, my lord. So all that.
we'll await
No,
the.
my lord, the problem is that the registry, my lord may see the order of the coordinate bench. I have given a copy.
You mentioned before Chief Justice.
We mentioned yesterday.
Yes.
The Honorable Chief Justice requested us to mention it before your lordships to pass an order tagging both matters and requesting the permission to be taken up before the appropriate bench. Unless my lord passes an
Reason
order.
is not there with me. How can I?
No, my lord may say that both the matters be tagged and be placed before the Honorable Chief Justice for appropriate direction. Thereafter, the Honorable Chief can assign it to whichever.
Right, and I understood. What I'll do is I'll send it to
So
this
a
matter
similar-
to
yes.
Chief Justice, and they will get it tagged.
An order in similar lines may be passed in this 480.
Right.
So that one bench can be assigned.
It 441, right? 69 before. The petitioner has essayed the order dated, where is that? Order dated 12/2024, whereby the learned court below has allowed the application under section 457 CRPC.
451.
Sorry, 451 CRPC, releasing the vessel, however, imposed various conditions. Therefore, the petitioner has moved this court for relaxation of certain, for modification of certain conditions. Meanwhile, the opposite parties have challenged the order dated 12/2/2024 by filing criminal revision number 93 of 2024. 90. The criminal revision is not assigned to this court. So therefore, the present criminal miscellaneous petition, which is arising out of an entry model, may be tagged with the criminal revision 93 of 2024 and placed before Honorable Chief Justice for listing the matter before appropriate bench. Tag and let it go anyway.
No, item number 66, an urgent copy because they might call him many days. 66, that
3 days, he
today only copy, yes. Today urgent copy. 66 that.
First case, Mr. Bhokta is appearing with him. Second, Mr. Udit Ranjan Jana is appearing.
Right, take the name. I think that is a balanced thing, you know.
We would cooperate, my lords. He is here.
Cooperate, it may so happen you are unnecessarily apprehending.
No, there is absolutely.
He may not be required.
My lords, he was saying that in Vietnam, there's death penalty for this. He wants to clear his name. They will cooperate whatever they want. He will be at their disposal. One small indulgence, I'm saying, my lords, in the bath. He doesn't understand English. So one of my friends would be accompanying him. Otherwise, they would
Your
find
friend
it
knows
difficult. He and there is one more interpreter. So three of them.
Sometimes the department is taking all arrangement in this.
Yes. So it would be easier for them because
So in what I came to know from this results also, this captain who is he also not know this.
There will be confusion on that. Mr. Mishra further submits that the petitioner is not well versed with English. So therefore, he needs an interpreter at the time of interrogation. Mr. Padi submits that the official interpreter is always available. In case the official interpreter is not available, the petitioner may be allowed to accompany with his official interpreter at the time of interrogation.
Educing evidence or whatever.
If you have,
We are all grateful.
Yes.